Well, good evening, and happy Friday to all of you tuning in live. And for those of you on replay crew, good morning, good day, good afternoon, good evening, and good night. Hope that you guys are all doing wonderful. I hope you had a wonderful week. So, yeah, I'm late. I'm very late. Two factors led to me being late tonight. One, rain in DC. I don't know why people lose their mind when it's raining outside. I don't understand this concept. I do not understand the concept of rain means that we are just all going to lose our minds and forget how to drive. That's one thing. Second thing, StreamYard decided it wanted to be glitchy tonight, like very glitchy. I can't see the live numbers. I can't see some starred messages. I can't see the live chat. It's updating slow as can be, and it looks like it might now be updating. we are professionals. So, welcome to all of you. Happy Friday night. I hope you guys are all doing well. I've had a good week. So we are continuing our discussion and our recaps of the Maya Kowalski case, the take care of Maya case. This is the case of Jack Kowalski, etc. et al., which means that Jack Kowalski, Maya Kowalski, Kyle Kowalski, and the estate of Beata Kowalski versus Johns Hopkins All Children's Hospital. This is a case taking place in Florida where the facts have been previously documented in the Netflix documentary Take Care of Maya. The facts revolve around a 10-year-old child, Maya Kowalski, in 2016, who was admitted to Johns Hopkins All Children's Hospital with a prior diagnosis of CRPS, complex regional pain syndrome. After being admitted to the hospital, there was some conflict as to how it was the hospital would go about treating her and what diagnosis was appropriate. That resulted in some conduct by the hospital that the plaintiffs allege was both malpractice as well as false imprisonment, battery, etc. The unfortunate part about this case is that there was a shelter order that was entered, and following the shelter order, on January 6th, they had a hearing, and at that hearing, Maya Kowalski was prohibited from having contact with her mother. The next day, her mother, Beata Kowalski, unfortunately took her own life. So the estate and all of the other individuals are suing the hospital for $220 million in Florida. The case has been covered extensively by both me and others on YouTube. One of those people covering the live cases is Recovery Addict. Why am I struggling right now? Oh, because glitches in the system and the glitches in my brain. So because the case revolves around sensitive issues, I do run a banner at the bottom of the screen so that when people come in and tune in, they understand what they're tuning into. We are discussing issues that involve treatment. It's involving someone who's afflicted with chronic pain and the various treatments that are available for them. You will not hear medical advice on this channel. You want to hear legal advice on this channel. I give legal commentary on this channel. Why are we listening to the guy on the screen? The guy on the screen, me, Rob, hi. Very nice to meet you for the newcomers in the chat. I am a lawyer. I have been practicing law in the field of domestic relations litigation, meaning I'm a trial attorney, for over a decade. And this area of law, this particular case, has an overlap with domestic relations significantly in the removal proceedings and the situations involving the treatment of this particular minor child. So that's why we're here. That's what we're talking about. I'm going to go ahead and throw the banner up. And I'm going to ask you guys how you've been doing this week. Have you been watching this trial? Where have you been watching this trial? What have you been thinking about the trial? Because I've been kind of scratching my head after today's hearing. And after I do what I promised I would do yesterday, which is pull up one of the last witnesses from yesterday, I'm going to go into today, but I'm going to take today's proceedings a little bit out of order because we had some questions at the end of today that really had me, like I said, scratching my head as to what's still on the table. What are we arguing about? What's happening? I knew I got it right. Recovery Addict. My gosh, I was watching over there today. The chat has been remarkable over there. He has been remarkable in addressing these issues. He says some very kind words about the channel. I say some very kind words about him and his channel because he's deserving of it. He might not think so. Says he doesn't think so. I think he is. So let's go ahead and get into some of today's, well, rather recapping of yesterday's live stream content. I have this volume gained up 600%. It is quiet. It is a court feed. Court feeds are notoriously sketchy as far as audio. You either have to struggle to hear, turn your volume all the way up, or you get your eardrums blown off by a microphone that's a little bit too active. So that's just a warning for people that are watching. Don't turn your TV up. Don't turn your monitor up. I will adjust the mic as best I can here. And I will go ahead and reduce my volume when I'm playing the court feed so that we can all be on the same page. That is kind of where everything is and how we're going to start everything. And yeah, I see the chat calling for a swoop, and I think that's an appropriate way to get into the testimony. So let's go ahead and swoop to the testimony. Needed that today. I needed that today. Mr. Unicorn, thank you for helping us. So coming to the stand, we have Johanna Klink, who is a nurse in the PICU. And her testimony, I'll summarize a lot of it because I want to get to the jury questions because those are my favorite. And I have a special guest appearing via yesterday's live stream for some of the jury questions because we didn't get to hear them live, but someone did because they had the Zoom feed. And that's with permission, of course. Let's go ahead and get to that. Before I do want to, I just saw this flying by. Hey, it's Maddie, first time catching you live. Welcome. I'm glad that you're catching the live. Resigned from my toxic job today. Congratulations. I know that was probably very hard leading up to that decision. So this is a nice distraction. Yeah, I know that was probably a hard decision. I'm glad that you have the future of prospects ahead of you. I'm sorry, the chat is getting me distracted. I have remarkable ADHD. Nova resident here too. The drive home was brutal. It was bad. It was bad. It was bad. So before I start playing testimony, here's some different things I want to explain to the chat. I have been covering this case since essentially the very beginning of opening statements. I didn't cover the opening statements themselves, but I've been doing recaps since the beginning of the arguments and the testimony. I'm doing a breakdown. It's going to feel one way or the other. I will be very clear when I have an opinion, and I'm trying to express a legal analysis of how the case is proceeding. In the chat, there are characters in this trial, both on the bench, on the either side of the bar, both plaintiff's counsel, defense counsel, and the various witnesses. We can comment about everything that they're saying. We can comment whether we believe, disbelieve, whether their demeanor might suggest that we don't believe them, but we're going to be respectful. I'm going to be respectful. We are going to be respectful. This is not you jump in here and start throwing daggers. So I say that because there was a lot of stuff that I saw in a lot of other live streams and in the Law and Crime chat that really kind of bothered me. And I don't like doing that. I want this case to proceed. I want to hear and learn from the trial. There is a person in the chat that you guys will see from time to time, Jules. Jules has been in court every day, and Jules has been communicating with both me and Recovery Addict, giving us little updates here and there, tidbits from inside the courtroom, and she's here to share her thoughts as well. So let's go ahead and get on with the testimony.
Okay, Nurse Klink, there's several questions from the jury.
Oh no.
Have you ever worked?
I went too far because, what did I say before? We are professionals. Defense calls. There we go.
Did I hear always? I'm glad. That's a very strong statement.
There's Ms. Lawrence. And there's Jules right there.
It's like, I just want to know what plan that is on because I don't always get that. So
I'm sorry, who is the defense calling?
The defense calls nurse practitioner Johanna Klink. So like I said, Joanna Klink is a nurse practitioner in the PICU, the Pediatric Intensive Care Unit at Johns Hopkins All Children's Hospital. Her testimony, which I will very largely summarize, the direct testimony, because I need to get through the stuff from this afternoon. Joanna Klink's testimony basically is surrounding Maya Kowalski, her demeanor, and Maya's demeanor while she was in the PICU. Maya Kowalski giving the medical history, the relationship, rather, the dynamic between mother and nurse practitioner. And then also her observations of Maya. One of those observations was Maya using profanity or saying things that were rather extreme, directed towards Dr. Tepper Sanchez, who we covered yesterday. That's the sum of her direct. I'm going to give her a chance to introduce herself.
Can you please state your name?
Johanna Klink.
And what is your current occupation?
I'm a nurse practitioner.
Can you please give the jury the benefit of your education and training, beginning with college, and any degrees or licenses you obtained over the years, please?
Yes, I have a Bachelor of Science degree in biology. And then I went on to become a nurse. So I have a Bachelor of Science degree in nursing. Then I was a nurse for some years. And then I went back several years ago and became a nurse practitioner. And I'm a family nurse practitioner.
And when did you first become a registered nurse?
2001.
When did you become an advanced practice registered nurse?
2021.
Can you explain the difference between a registered nurse and an advanced practice registered nurse?
Yeah, so a registered nurse is most typically a bachelor's degree. Sometimes it's an associate degree, but for the most part, it's a bachelor's degree. The nursing, what a registered nurse does is follows the orders that would be given by a nurse practitioner, which was considered a mid-level, or a physician. So we follow the orders. We monitor vital signs, we monitor the patient, and then we report to the physician. A nurse practitioner is one who works is like considered a mid-level, and will write orders and make a diagnosis. And registered nurses don't make diagnosis. They follow the orders of a physician or a nurse practitioner or physician assistant.
Now, before you became an APRN, can you describe your work history as a pediatric intensive care nurse?
As a pediatric intensive care nurse, I started in Children's National Medical Center in Washington, D.C. I was there for 2 years, and I was in the pediatric intensive care. I was for several months in a respiratory care floor in the acute care, and then I went straight to the pediatric ICU. After that, my family and I moved to Seattle, and I worked in the pediatric intensive care in Seattle. While I was in the pediatric intensive care in Seattle, I also had experience in cardiac ICU, some in the neonatal ICU, but predominantly was in the pediatric ICU in Seattle. Then my family and I moved from Seattle to Florida, and then I worked at Johns Hopkins starting 2010 until I believe it was 2021, 20, something like that.
And when we say PICU today, you understand that to be the pediatric intensive care unit?
Right, we call it PICU, but it's PICU, Pediatric Intensive Care Unit. Yep.
Can you give the jury an idea of what a PICU nurse at All Children's Hospital, or anywhere for that matter, does on a daily basis?
Well, the pediatric ICU, like I said, we follow the orders of the doctor, nurse practitioner. We're there for monitoring vital signs, patients' status changes. We report to them when we see changes in status. We administer in the pediatric ICU and in the ICUs very specialized drugs that are not given on like acute care floor. So patients come there for those specialized drugs. They come for advanced therapies. They come to be, if they're on ventilators, they have to be in the ICU. It's that's pretty much what we do. Take care of the patient. We give them, we look after their skin. We turn them. We help them. We give them their medications.
Did there come a point in time that you came to be involved with the care of Maya Kowalski?
Yes, I did.
And am I correct that you served as Maya's bedside PICU nurse on October 7th of 2016?
Yes, I did.
And in addition, I believe that you also served as a PICU charge nurse at All Children's Hospital at a few points in Maya's admission as well. Is that correct?
Yes, I was.
Can you please describe for the jury what it is, what role a PICU charge nurse serves?
Well, the PICU charge is more of a supervisory role. We control kind of the flow in and out of the ICUs via admissions, transfers, discharges. We're there for staffing. We assign patient assignments to the bedside nurse. We also go to rapid responses on the floor, and that's where in another unit outside of an ICU, if a patient is having some type of a respiratory or cardiac decompensation, the charge nurse will go there and assess the patient if they need advanced treatment, if they need any kind of CPR. We're also there for the code blue. If y'all know, the code blue is when somebody's in a cardiac respiratory arrest, we're there for that. And we monitor patient flow. We keep an eye, make sure that the nurses have what they need for their job that day. We go to the staff meetings, and we also go to like care conference meetings just to oversee what's happening with each patient in a big picture.
When you encountered Maya Kowalski at L Children's Hospital on October 7th of 2016, how many years of nursing experience did you have at that point, approximately?
I had about 16 years of pediatric intensive care. No, yeah, it was about 16 years. It was in 2006, yeah.
I'd like to take you back in time to the afternoon of October 7th of 2016 and pick you at L Children's Hospital. On that date, you served as Maya's bedside PICU nurse, correct?
Correct.
Do you remember the afternoon of October 7th?
I do.
And why is it that you remember that afternoon?
It was a
Okay. We are going to summarize. We're going to summarize because I have to get to some of the legal stuff. So the summary is essentially that she remembers this day that Maya Kowalski presented in pain. It was, she did testify that Maya Kowalski was very clearly demonstrating pain. She was groaning, displaying signs of pain, etc. She then testifies about Beata Kowalski and the patient's medical history, Maya Kowalski's medical history. Testified about Beata Kowalski standing over her shoulder while she entered that patient history into the computer. I apologize. I am still suffering from this cough. So I'm trying not to cough into the microphone, folks. Yes, I'm not feeling great. This is not my best. I'm not usually like this. So Beata Kowalski standing over her shoulder, entering the information about the patient's medical history. And then there's additional testimony about desiring ketamine for the pain that Maya is expressing. This particular nurse testifies that Beata Kowalski was asking for ketamine to be administered or pain medication to be administered when Maya, based on this testimony, was near sleep, where essentially she was already passive. She was falling asleep. She didn't need it, but Beata Kowalski says, give her pain meds. Testifies to the fact that Beata Kowalski was belligerent, a little bit forward and direct. Testifies that Maya Kowalski was observed kneeling, moving around on the bed in a fashion that wouldn't suggest that she was in pain in various instances, and also testifies that Maya Kowalski was overheard using various profanities directed at Dr. Tepa Sanchez and others about her medicine. Give me my effing ketamine, all of this stuff. This was a summary of the direct testimony. The witness maintained credibility. I don't think that that she actually hurt herself as far as credibility on direct. Now, I'm going to pull up a comment because the comment that I'm pulling up is a highlight of one of my concerns. Island, shot clock. Thank you. Plaintiff, 9 hours, 30 minutes remaining. Defense, 35 hours, 10 minutes remaining. Mistrial requests, plaintiffs 2. They've both been withdrawn. Defense, 4. Summation or an estimate of the objections. I think this is from Recovery Addict, 1,209. So the shot clock. The shot clock is a factor right now. I have been critical of the plaintiffs as far as not utilizing their time in cross-examination and in their direct. They consumed a great deal of time in their direct, the presentation of the direct case in chief. It was a lot of time that was then removed. The judge then granted both sides 4 hours of additional time. That triggered a motion for a mistrial by the defense, who felt like they were being sandbagged. Like, it's not fair that you gave the plaintiffs 4 additional hours. And even though you gave us 4 additional hours, we could have used that during cross-examination of their witnesses. The judge said mistrial denied within the sentence that Shapiro asked for it. And the shot clock is what is killing me here. I wanted to do this because I wanted to go to Mr. Anderson's cross-examination. And I'll explain why.
It was an unusual day.
We get spinny wheel here and there. It happens. I don't like it. I get angry at it. But see, I don't like spinny wheel. Come on. Not my internet, folks. It's just the fact that a lot of people are watching these streams. Here's Cross.
Wow, with all that experience, you must have been really good at charting everything that was important, right?
I chart what I can get in there. Yes.
And what's important, right?
Mhm.
Really, it's something astonishing happens. You're going to put it in there, right?
Nurses chart as much as they can get, as much as they can chart, as long as they're doing their patient's hair as well.
Well, why is it that I can approach and show the witness from all of your charting here over a few days, most of what you said about all the words and all the actions is never charted? Why is that?
Well, first of all, we do chart all the vital signs. We chart the meds. We chart what goes in the patient. We chart what comes out of the patient. Those are things that we for sure, we chart, we get in there from the medical point of view. The other stuff, if we can get some time to put the things that some of them are glaring. The incident with Dr. Teppa, where she called her that name and she said the whole words, the whole thing. I only gave the initials, but she said everything. The reason I didn't chart that is because most of our charting that we do for that is a communication tool in the hospital. Like I wanted, if we chart that the patient got out of bed.
Every second that this witness is consuming in answering this question is going against the plaintiff's clock. I loved the question. I loved the lead in. You chart everything of significance. Boom. That flag is popping up in my head as, yep, okay, now I know where you're going with this. Why is this not in the records? Don't give that witness the opportunity to give an open-ended question like this. I think these witnesses have an understanding that time is a factor in this particular case. So if you are cross-examining a witness as the plaintiff and they're consuming all of this time, you can't be giving them open-ended questions. You have to iron in on it. I loved the way that he opened that cross-examination. If it was important, you put it in the chart, right? Go straight to the next question. This isn't in the chart, is it? You didn't document these profanities anywhere, did you? But instead, there's 2 more minutes off of the plaintiff's time.
Because when physical therapy comes, they will look at the child's chart and says, oh, okay, the kid was out of bed today. So something like that is what I would convey to the ICU team, specifically to the attending that's there. And Dr. Teppa was in the room. So this was during rounds. Everybody was there. Anybody that needed to know about what that kind of those expletives, anyone was already there. There would be no reason for me to chart it. If I thought that I was going to be here where I am now, yeah, maybe I would have charted it. But Dr. Teppa knew. We all knew. I'm not going to. It's more that kind of stuff is for the purposes of communication in the hospital. I didn't think I'd be here.
Anything else?
That's it.
Not your explanation? Sure.
Yeah, I chart what I.
The sarcasm is an attempt to regain control. That was an attempt to say, I gave you the opportunity to speak your piece. That's it. That's all you want to say? Okay.
Can chart. I mean, there's 12 and a half hours that we are there on the bedside. We are running. We're monitoring the patient. These kids are critically ill. We don't chart everything that's a communication that comes out like that. And like I said, the thing with Dr. Teppa, yeah, maybe I should have, in retrospect, if I knew I was going to be here, but at the time, anyone who needed to know was there.
Aren't you allowed to have either your phone or a cell phone from the floor on you as you make your rounds?
I believe we are, where we were.
Why is it, after 12 hours of all of this, there isn't a single photo or video or surveillance or anything else that confirms what you're saying?
Well, there's no cameras in the room. This happened in the patient's room.
Missed opportunity by the plaintiffs here. I caught it. I don't know if anyone else did. Missed opportunity. I don't know if it's fully missed. Do you guys remember the plaintiffs trying to introduce photographs of the cameras that were in the room, in the various rooms, when they were saying Maya testified this was in her room? It was in her room. And the issue that was being presented at that point in time was that there wasn't anything in there to suggest that they weren't in the room. You didn't subpoena the documents. You didn't ask for the footage. You didn't do this. And then it was a foundational issue. This one was, for me, if I'm plaintiff's counsel, I'm keying in on this question and saying, Judge, They just opened the door. They just opened the door to the photographs, to the video. They had a witness who testified that there's no cameras in the room. Well, look, she has a picture of a camera in a room. So that I'm remaking that argument. And it was so quick. It was so quick.
You know, they don't have, unless they need to put it up for a specific reason, but there's cameras in the halls, and we're not allowed, I don't take pictures of any patients. We're not allowed to take pictures of the patients. I don't videotape the patients. I don't do that.
I
That's
see.
it.
So you nurses are not allowed to take pictures of the patients, right?
Mr. Anderson. Love this. I love this. This was not a part of his expected cross. He did not expect to get into this. This is a good move. This is a good move because she just made the comment, we're not allowed to take photos of the patient. Well, now we have photos of the patient. Now she has busted that door open. Here comes the next big ticket item of his cross.
Never just testify to.
Yeah.
Okay. So I guess taking her into a room and stripping her down to her bra and her shorts and taking about 8 to 10 pictures of her, that would not be appropriate, would it?
Objection form, overall defense, foundation.
There are times when there are pictures taken. Absolutely. They are taken for medical purposes, 100%.
Oh, I'm sorry. I'm sorry. I'm going to get you better pause.
And
There we go. Better pause. Did you catch that part too? So now what am I on the scoreboard? I'm 3 or 4 points for Anderson here. There are times when pictures are appropriate. They are taken for medical purposes. They are taken for medical purposes. There are times when photos are allowed. They're taken for medical purposes. Well, ladies and gentlemen of the jury, I will refresh your recollection of Kathy Beatty's testimony about risk management directing the taking of those photos, or her making the independent thought of taking them and them not ending up in the patient's medical file. That is a key point I think they need to focus on in making this argument. Come on, spinning wheel. We can do.
that's undeniable. But for me to just do it on my phone, to take a picture of the patient, I don't have any reason to do that. If it was a medical reason that somebody needed to do that, that does happen. That I know happens.
Double down.
People do that. I know different entities will do that. But as the nurses, no, I don't take a picture of a patient on my phone. Maybe unless somebody else has a reason to do that, possibly. But I don't. I'm answering for myself. What other people do is you have to ask them.
Anybody, anything else?
No.
You'd like to add? Okay. So if somebody were, say, to take a child and put them in a room and videotape them without their parents' consent or their consent, that would also be something that would be against your policies. Agreed?
I disagree.
So it's okay to videotape children without the parents' consent or anyone's consent but you, correct?
That's not what I said.
Well, if it's not the parents' consent and it's not consent from another authoritative source, that leaves you, right? So
Sustained.
So do you or do you not have the authority to do what I just described? Take a child into a room under false pretenses of an EEG and put her in that room, video her without her knowledge. Oh, put a commode just out of reach to see if you can tempt her to get over there.
Compound.
So who gives the authority to do something like that?
Objection, argumentative, compound, foundation.
Compound. Break it up.
Are you, did you
Questions,
work
break
with
'em up.
Kathy Beatty at all? Ever?
I did in the past.
Not anymore.
Correct.
Not since she left.
Correct.
And before that, though, was she a PICU social worker?
Yes.
Were you a PICU nurse?
Yes.
So you saw her about every day, right?
No.
How often?
Maybe once a week, once every 2 weeks. And if she had a patient that involved me, we had the same patient at the same time, then I would. But if I had a patient that Kathy Beatty wasn't working with, then
Okay.
Okay. So here's my commentary. This snippet, what are we, 5 minutes into cross? This snippet, that's your cross. That's your cross. Get up, hit the points, sit down. There's a lot of wandering that happens after this, and a lot of testimony that kind of makes her look a little bit maybe less than reputable. But here's the thing. I think she maintained a good bit of her credibility. She really did, in my opinion. But the thing is, make your points. You've made them. You have attacked her credibility in two very specific things. And you've done it to the betterment of your case. See that little time bar at the bottom there? That thing there? That is how much more time he continues his cross-examination. You don't have the luxury of the wandering cross. I know you want to, but it's not a deposition. So I wanted to make that point with this particular witness because I thought that this was a good example of good cross and then wandering. The Michael Jackson thing, these were things that were kind of argumentative. I think if you're focused on the points you need to make, because that's what this is about, you need to make the points. You make the points and you can move on. There might be one or two others, but it's basically saying, boom, 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 1, 2, 3, sit. The jury's asking questions too. Use that opportunity. So, speaking of our favorite litigant in these cases, let's go to the jury.
So with as stunning as all of this is, I mean, with a 10-year-old.
No, I want to go to the jury. Not redirect. I want the jury. All right. So the jury says we've got questions. And before we do that, we have to roll we are the jury. We have questions. Little bumper. So Emily, take us away.
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
Okay, that's the Law Tube jury. But this jury, we're bringing this jury. And for these particular questions, this witness gets excused. And unfortunately, we in the viewing audience missed out on the exchange and what was taking place. You know who didn't miss out on the exchange? A new friend of mine. A new friend of mine didn't miss out on the exchange. And I say a new friend because this is a new friend, and I do view him as a new friend. This is a recovery addict. This is with his permission. I asked him. So recovery addict, I said, because he was watching the Zoom feed. And on the Zoom feed, you can still hear stuff. So recovery addict is on the Zoom feed. So he does something that's pretty remarkable and listens in and is repeating it, essentially trying to verbatim of these different questions and the attorney dialogue at the bench of what's been happening. Volume might be a little iffy, so check your ears, okay?
He's got a little more freedom to wander on a deposition than here.
Oh, look, he made the same,
Of course,
same
that stuff
argument.
gets
There we
ruled
go.
out. And they've killed the mics. No. I'm gonna have to hold tight. Okay.
Okay, my friend, tell us what we're hearing.
I'm going to tell you what's the judge is saying. The judge is saying, did you report that? Did you follow up at a later time? If not, why? Prior to working with Maya, how many children have you cared for with children with CRPS? When you say these are your only options inconsolable, do you have the option to free text? I'm just saying verbatim what the judge is reading. No objection from either side on that one. Red number 3.
All right, recovery addict. We're gonna do you dirty. We're gonna speed you up to 1.5.
Did you remember the condition of Maya's feet on admission? How many residents were in the PICU on the 9th? During your 12-hour shift, how much is rotation? How much is spent documenting? How or have you ever had any kids in extreme pain use curse words? There's more, says the judge. No objection from Mr. Shapiro. Judge says, this says, not a question. Let me just read it. I'm trying to figure it out. Can plaintiffs, counsel, and defendants refrain from speaking, huffing, and laughing during responses? I can hear fine, but easy to miss details during answers. If the lawyers just heard it. So that was instruction to them. Judge says, move on. In your experience, does medical staff have a general sensitivity to direct opinionated parents? No objection from Shapiro. No objection from Mr. Anderson. I do apologize. I'm not allowed to let you hear the audio, but I can tell you what I hear of the Zoom. So Zoom audio is on, courtroom audio is off. Next question. As a nurse, would you not want to chart disruptive behavior that a patient was displaying in her chart? As a rule, if it is not documented, it did not happen, question mark. We heard earlier that all children's hospital staff has nicknames for the patients. Can you tell me the nickname you had for the plaintiff? This is incredible. No objections? Red number 5. Nurse, are you attesting to this juror that by mouth or by
This juror,
personal message group or by official medical records that for 3 months, 90 days, only a select few had knowledge of, quote, ketamine girl, unquote? Yes, only a few. Confirming with all these, quote, team meetings, unquote, taking place to review patient treatment plans, no nurses or doctors commented on the possible validity of CRPS diagnosis and its serious effort to investigate Maya as having CRPS and treating for CRPS. Mr. Shapiro says, maybe see the question, Your Honor. Okay, so this jury, we've got another one of, are you saying to this jury, this is crazy. I was supposed to wear wigs and change my voice as I'm doing this. This is role play, but this is the best I can do. Shapiro says, we object to this question on several bases. Judge says, which one? Shapiro says, one is argumentative. Judge says, no, which question? Shapiro says, I think it's one question, or I read it as several. The judge says, I think it was several questions. Shapiro says, starting with testimony to this jury, it's argumentative. The question is asking for her as a PICU nurse, her opinion about what went on after her care, and then asks what happens over the next 90 days. And it asks for her to speculate on the knowledge of what other people knew. Then it asks for the comment on what other doctors knew or suspected about the validity of the diagnosis. So based on all of those bases, we object to the entire sheet and foundation. Mr. Anderson says, to me, that sounds like perfectly understandable questions based on the witness's testimony. Hughes says, but the witness testified she had nothing to do with this patient after the first week. Judge says, well, it's asking about team meetings. That's fair. Shapiro says, the tone of the question is highly argumentative. Judge says, well, I can remove the argumentative language, but the question itself, though, needs to be asked. So I'll remove the argument testing language. Are you a testing language? Sorry. So I'm listening to the Zoom feed from court that we're not allowed to play the audio from. Judge says, okay, anything else? Anderson says no. Mr. Shapiro says, one moment. The judge says, different issue. And Shapiro says, yes. Mr. Hunter says, I'm going to move to the back row to permit counsel to. Oh, I moved to the back row. I've become aware from a lot that's coming from the gallery. The lady just to the left on the back 2 row, there's snickers, there's laughters. There's a lot of commentary coming there that I think needs to be reined in. And if I can hear it, the jury can probably hear it. Judge says, well, I suspect everyone in the gallery just heard that. And if you're in the gallery, I would request that you refrain from making comments or commentary or laughing or snickering during witnesses' testimony and ask the court deputies to keep an eye on it. Thank you. Let's bring in the jury. There we go. Okay.
Okay. Applause. Mad respect. Applause. Like that was. You guys don't understand how hard that is. That's real time rereading. And he's allowed to do that. But he has access to the Zoom feed and he's allowed to do that. He's allowed to repeat what was said. But he can't play it live. He can't rebroadcast it. That was so cool. That was so cool. I immediately messaged him and I was like, hey, bud, can I pull this up on my stream? And he goes, yeah, sure, no problem. So please, if you guys are interested in watching this trial live, I would very much say avoid law and crime, avoid a lot of the other chats, avoid a lot of those other things. Recovery Addict is doing a great job with this. Great job with this. And Jules is clarifying, no, it was not her. Jules is the lovely lady in the white behind Jack Kowalski. She is not in the back row. It was not Jules. So, I mean, just my hat is off that, and hearing something live and giving the live recap. I'm getting from the field that, yes, they are saying the witness wants to, okay, they really do not like this witness. Not to mention Recovery Addict has one of the smoothest voices I've ever heard. So I'll listen to that all day. Not going to lie. So let's go ahead and see what this jury asks of our witness. And then, oh, come on, spinny wheel. We can do this. Yes, I know I can download the videos. They're massive files and it takes a minute. Not just a minute, but it's also like I still get spinny wheel when I try to move in a massive file that large. So,
Hey, Nurse Klink, there's several questions from the jury. Have you ever worked with CRPS?
No.
Do you know how to work with CRPS patients?
I can't just answer that in a yes or no.
Well, explain what the best of your ability.
As a bedside nurse, as a bedside RN, our job is to follow the physician orders, and we treat as per order. So I don't go out of my scope of practice and do anything differently. I see what the vital signs are. I administer the medications. I take care of things like her skin and things like that. I don't have a special, you treat them this way or that way. My job is to treat the patient as per physician orders.
Was Maya in any pain when she was cussing?
Maya did not say she was in pain. She would get very angry. She would get agitated. And I know kids can get that way if they're in pain. However, Maya was 10 and 10-year-olds would tell us if they're in pain or if something hurts them. Even if I ask Maya, or if it's like the pain scale, you can ask her, Maya, what's your 10, pain? Are you in a pain of a 10? She would say, yeah, she can say I'm a 10 because she's 10 years old, but she never actually said. And I remember she never said, this hurts, I'm hurting, this hurts me. My arm hurts, my leg hurts. She didn't say that. And that's what I thought was so unusual, because a 10-year-old would tell you younger kids would say, my leg hurts, my head hurts. But Maya never told me I'm in pain.
Did Maya calm down after she got her meds?
Yes, Maya would calm down after she got her meds. I remember she would go up and down a lot. Those meds are heavy duty. Those meds were strong meds. Anybody who is on propofol or ketamine is going to be pretty much knocked out. So yeah, I mean, she would respond to pain meds.
Okay. As a nurse with 20 years experience, did you follow up with anyone if you had such a conviction that meant something, quote, my life is lies, end quote?
I think at that time I had moved from there. The physicians had known that because we had talked about that. Maya would shut down. I didn't have her again after that. It was hard to talk to Maya. Maya would kind of open up when she wanted to open up. I didn't ask her again. Things had started to become very difficult in the ICU. It became difficult. I didn't follow up, but I was hoping, because she was still there and they knew that the rest of the team would take over, but I wasn't her bedside nurse. And the ICU started to escalate in tension and stress, and it was no way to go back and to do that. And I just couldn't.
The statement, my life is lies, did you report that to a doctor to follow up on, or did you follow up at a later time?
I discussed that with the doctors. I think things were starting to, like I said, things were starting to escalate. Tension was starting to go up. They knew. And my job as a nurse is to report. That's what RNs do. We don't step out of that scope, but I did report. They knew, and everybody, I think that they started to see, well, yeah, she couldn't move her legs, but she was all over the bed. So I think the pieces were starting to come together. But my job was to tell them that she said that. And I put it in the chart to make sure that it's in writing, that the team knows. and they were notified, and then they take over from there. As a nurse, I mean, you don't, that's not out of my scope, and I have to stay in my scope of practice, and the doctors take over from there, from my reporting. And that's pretty much what nurses do. We are at the bedside the whole time, and we report changes as the doctors are in different places. We're assigned there, and we report things and then hand it off. But yeah, I mean, I wish she had finished that. That was shocking when she said that, and I wish I had the opportunity to do it, but there was nowhere for me to go from that, unfortunately.
Well, that
Prior to working with Maya, how many children had you cared for with children with CRPS?
I don't know of any of them that had CRPS that would come into an ICU. I worked in ICUs, and so I don't know that they would probably be somewhere in outpatient but I worked with kids that had pain, and that was my job, is to treat pain. So they could have neuropathy from chemo, they can be in car accidents and have trauma. So my job was to deal with the pain and not the diagnosis. They can have whatever diagnosis, but I'm there to take care of them holistically with their pain, whether or not they have leukemia, a car accident, or CRPS. If they have pain, then I'm there to help them with that.
In response to the term inconsolable, when you say these are various options, do you have the option to free text?
I heard inconceivable. I didn't mean to hear it, but I heard it in my brain. Inconceivable. I'm sorry, folks. That was a squirrel.
Yes, I do have the option to free text. At the time, that was the first day that she came in, and there was so much going on in the beginning with the medications and the yelling, and the tension was rising. I didn't go back and free text. That would have been a good idea if I did. In hindsight, yeah, I should have free text. But those were the options, and there was just so much coming at me that day. I couldn't go back and start changing things because ICUs are stressful. They're intense. That's why they're intensive care units. There's alarms. There's all kinds of things going off, and we're used to that.
True.
This was way
Very
above and
true.
beyond in the level.
Very true. ICUs are stressful. I have no doubt that that's correct. And I get what she's saying. You don't have to. Ms. Klink, you don't have to explain as much as you are. Original explanation with fewer words is more than enough. I swear, law and crime
Of stress and the yelling, they were swearing. I should have free texted and said what I meant. I didn't, but there was just so much coming at me. It was hard to even stay afloat.
Do you remember the position of Maya's feet on admission?
Good
No.
question.
How many residents were in the PICU on that night?
Then that night, I was working on the day shift. There would have been one resident that would have been assigned to her. I don't know which night they're referring to, but I worked on the day shift. And when there were the residents in the room when that incident happened where she cursed at Dr. Tapa, that's when there were multiple residents. There was probably 2 or 3 residents.
During your 12-hour shift, how much is rotation? How much is spent documenting?
We spend a lot of time documenting. The amount of documenting that we do on an admission, I mean, we are clicking through pages and pages and pages. It is a lot. And you just try to stay ahead of it. Meanwhile, you're getting orders that are.
Welcome to the red tape that is hospital admission. Welcome to the red tape that is hospital admission. The level of documentation, the level of writing, the amount that they have to put into paper, the questions that are asked of you. I understand why it's there for their liability purposes. This is one example of that, but my God.
They're coming in and they're changing. The orders are going up, they're going down, do this, you're doing that. So we spent in the beginning, there could be several, I would say 2 hours on an admission of just doing the whole admission profile. There's a lot of questions. Do you have a dog? Who lives with you? I mean, there's just so many. And I think that's where I got tripped up by not maybe going in and doing some more documentation, because I'm responsible for all just the basic stuff that comes in. And there's pages and pages and pages. And then I have to take care of the patient. So after the patient gets settled in, like that next night, that next day, it gets a little easier because all that intake stuff is very intensive to complete.
Have you ever had other kids in extreme pain use curse words?
maybe it's not really, not that much really. I think not that often. If they're in pain and I see that it's matching up with the monitor and I could see that there's pain issues, I could see their heart rate is up, their respiratory rate is up. Like I said, I'm very serious about the child's pain. It doesn't go to the point where somebody's swearing that they want pain meds, because I see they're in pain and I act on that. That was always one of my things is making sure that they're not in pain. I'm not going to wait and say, oh, I'm not going to give you the meds, wait until I'm done. I act on pain quickly. So it doesn't really happen. It doesn't really escalate it to that point. And to swear, it was more of, I wanted my effing sedation. That again is as a nurse, I'm looking at it like, she didn't say she was in pain and she didn't look like so that's not, it doesn't typically happen that they swear when they're in pain. It could, but it doesn't typically happen. They get their pain meds when they say I'm in pain.
In your experience,
I don't know. I found her to be credible in this regard. I found her credible. I thought Anderson scored points on cross with if it's not in the records, it didn't happen. But her answer there to me, that telling you just from my experience with certain friends of mine who do that type of analysis, I thought that was sincere.
do medical staff have a general sensitivity to direct opinionated parents?
I don't know what a direct sensitivity for direct opinionated parents, but I think all of us we have all kinds of parents that come in. Direct opinionated is completely fine. You are an advocate for your child, and I'm happy about that. I think a lot of us have that kind of personality where we have a strong personality. You have to be in an ICU.
This is a good answer. This is a good answer. I appreciate the fact that this nurse has a ton of experience. This is a good answer.
And I'm not sad over it. This was not that. This was way different. This was very demanding, and the curse words were kept coming. This was different. There's many parents. Parents are very protective of their children, and they advocate, and that's totally cool. That's great, and I'm there for that. This was not a direct opinionated. This was the ICU had become toxic, and that's a lot for an ICU nurse who had been there 16 years in ICUs. This was not like other ICU admissions, and so no, we don't have a problem with people who are direct.
As a nurse, would you not want to chart disruptive behavior that a patient was displaying in her chart?
Good question.
I would chart disruptive behavior. It's now when we're looking back, I had Maya just in the first. All this stuff was in the first hours of admission, half hour. I had no preconceived notions. I didn't have any background to think, oh, well, wait a minute. There's patterns that's starting to form here. This was completely a blank slate. I didn't know about any of this. Maybe after the time had gone, I'd be like, I got to put this down. When Maya said my life's a lie and I'm tired of all the lies, then I did start charting, because I was like, whoa, there's something going on here that needs to be looked at. And I need to tell, and I did. And that is when it started. But in the beginning, I had no preconceived notions. I took everything at face value. And then things started to happen. And then you look and you're like, wait a minute, things are not what they seem to be. Something's going on here and it needs to be looked at.
Next question. As a rule, if it is not documented, it did not happen, ?
So in nursing school, and we are drilled on that, and that is true. But that really speaks to, did you hang this antibiotic? You can't say, oh yeah, I hung this antibiotic, but I didn't chart it. It's for the patient stuff that you do. If you did.
I get the question and I get her answer. So her answer is, I think if I was in her position, what I would have said is, I chart everything. But for example, I don't chart that the patient was wearing a blue shirt today rather than a red shirt. I don't chart that they had a specific necklace on their neck. So there are certain things that I chart of what I deem to be medically significant events, but I don't generally chart their outward appearance. Patient's hair looked very nice today. I got what she was saying here. I think there was a better way of her saying it, but I think she holds her own. This witness appeared credible to me. I didn't have a problem with her. I thought she did well. I think this is probably by far one of the hospital's most believable witnesses so far, at least as of yesterday. We get more today, but
Didn't, like I said, give this med, if you didn't do this bath, that kind of stuff is there. If you didn't do it, it's not
done because you didn't chart it. This is not the same. This is what somebody else is. We are not expected, and it's 12 and a half hours and all of this stuff is going on. I can't chart all of that. So it's not an expectation, at least it wasn't then. And it probably isn't now because it's 12 and a half hours to document what other people are saying. That's different. It's not like hanging the med. Did you give them a bath? Well, if you didn't chart, you gave them a bath, then you didn't do it. Those are two different things. That's what I'm responsible as a nurse to perform those duties. That's what that is. So that part is true. Documenting what other people say, that's not in that realm of my responsibility. When Maya said my life is a lie, I'm tired of all the lies, that I thought I needed to start putting,
And this is a point that I want to make because Morgan makes the comment here. Thank you, Morgan. Nurse Klink definitely got report from the ER that came with, quote, more info, end quote, than what was in the chart. And that's part of what I'm seeing here is Nurse Klink, I am sorry. That's a bad
Document
pause. Nope, that's worse.
because that was something above and beyond. But typically, no, we don't. And like with Bea, no.
That's not bad. Okay. There's more information that they have from outside sources. Every bit of information that we receive from people that we deem or believe to be credible affects how we approach every situation. If I were to tell you, and you trusted me, if I were to tell you, be careful when you talk to this person because they're a little bit wacky, you would have your guard up. You would be more attentive to words that are being said. You might even interpret those words differently than what they were intended to relay to you. A lot of this feeds off of each other in the hospital. This is the impression I'm getting, is that these healthcare professionals that are interacting with Maya and Beata, this is an environment in which information is flowing behind the scenes and it's influencing how these professionals are approaching the case. And I don't know that I'm critical of that. I think it's just a reality in how we deal with people on a day-to-day basis. Healthcare professionals get abused by both the system within which they work and the patients that they apply care to. Some of them are not the best. A lot of them, by and large, that I've dealt with are remarkable people, and they are in the job and profession that they love to be in because they love helping people. However, just like I've talked about biases is the desire or predilection for a specific outcome. And that bias can be formed by even a discussion or a coffee break or someone making a passing comment about how this person's awkward in their speech or demeanor. And even though you might not think it does, it might influence the way that you approach the next conversation. I have biases. You have biases. Everyone has biases. I think that some of this is fueled. Well, a lot of the commentary is fueled by, the pauses that you hear in her recitation of when she's trying to recount how it felt, how it was different. There's something in there that's both her direct observation as well as information that she has gained from outside sources. That's not wrong. There's nothing wrong with that. But it does lead you to the understanding of how we got to this place. How did we get here to this day, to this moment? I want you guys to keep that in mind when you're listening to these professionals testify, especially the ones that had direct contact with Beata, Maya, and Jack.
I wouldn't put that in the chart. That's not what I did.
We heard earlier that all children's hospital staff had nicknames for their patients. Can you tell me the nickname you had for the plaintiff?
I can say absolutely that's not true. I've not heard of nicknames for patients. I've not heard of that. I did not hear any nickname.
This offended her. This question offended her. And I think she knows these text messages exist. And she was just as shocked as everyone in the jury that saw them. This is her distancing herself from conduct that I think she believes she knows it happened. She does. She knows it happened. I think she is like, this is, When I imagine when she saw that.
Name for Maya at all. I don't even know. I don't know if I've ever even heard that people have nicknames for patients.
That part's a lie.
At least not. I never hear that in the ICU, and I haven't heard it on any of the ICUs where I work, where people's like, oh, I call them this thing, I call them this. It's usually some people say something. If there is, oh yeah, I have 554, meaning I have the kid in 554. But people don't. I've never heard people make up nicknames on patients.
Are you saying that either by mouth or by personal message group or by official medical records that for 3 months, only a select few had knowledge of, quote, ketamine girl, end quote?
I don't know about what everybody else knew. I don't know. From hearing that, sometimes there's so many kids that come in, and if there's something that is very distinctive about a patient, somebody will refer and say something about just so you can remember who this person is. I don't think it's done derogatory, but you have to have some way of remembering there's 29 bed ICU. Sometimes we float to the other units. It's hard to remember, oh, this is John Smith. And of course, now we remember Maya, but that's only because of all of this that happened. Sometimes you have to come up with some way to say, yeah, this was, whatever, to designate who that patient was, but not to be derogatory. It's just, somebody's not gonna remember, Susie Smith. It's hard. Some kids have, similar names. So
See, that's the part where it's like so you do know the nicknames exist. Okay, so I can't continue playing this part of the recap because I have to fast forward a bit. That's it that we're going to cover. Well, we haven't, you know what? A few more seconds of this.
So sometimes from hearing that, I think somebody may bring that up as a way to identify that person. But nobody, I don't think people don't have derogatory names for that, just so that people, I think that's what that is.
With all these, quote, team meetings, end quote, taking place to review patient treatment plans, no nurses or doctors commented on the possible validity of CRPS diagnosis and a serious effort to investigate Maya as having CRPS and treating her for CRPS.
Well, I think, actually, I know the ICU had the diagnosis of CRPS. I think that they went with the diagnosis of CRPS. But the thing is, that you have to treat,
But did they? That's the question. Mr. Brooks, get off my screen. Her answer right there. They went with the diagnosis of CRPS. They might have for a day, for a few hours. That part right there. I think she did the best that she could in the care that she gave. I think she had questions. I think she was very concerned. I think the hospital and the people higher up in the chain, the people that were directing her conduct, the people that were making decisions that were beyond just the person that was observing and documenting, I think the allegations at least suggest that they had serious questions. And the evidence that we've seen so far, they had serious questions about the CRPS. They did bill for it. You're right. They did bill for it. So they were operating on that. But were they though? But were they?
treat this child. So if she's in pain, you have to treat her pain. And I think that that's what they were doing. I don't think that the ICU, because I can only speak for the ICU because I was there. I don't know about the floors. But the thing was to treat the patient. The meds, those drugs that were being demanded are heavy duty drugs. Like you don't see people on these drugs. That's a big deal. So I think they wanted to treat her CRPS in a different way so that it's safe for Maya and start to bring the drugs down. You can't have a 10-year-old in a ketamine coma and on propofol. I mean, that's the drug that Michael Jackson died with. I mean, it's a heavy duty drug. It's complete sedation.
Your speculation and also not responsive to the question.
Sustain is not responsive to the question.
I'm sorry. I didn't mean that.
Right, these comments.
I think that,
Jury's going to disregard the lengthy response that was not responsive to the question.
I'm sorry.
Ouch. Okay. Ouch. Ouch. That part hurt. Let's go ahead and pull down the Nurse Klink. I'm going to remove the banner too, because we're just going to do a summary. So a couple good questions here that I saw. Have you noticed how many of the defense witnesses contradict each other? The defense is an entity. It's essentially the whole hospital. Having every person that acted as the hospital say the exact same thing is almost impossible. So I'm not surprised they're contradicting themselves. I think the jury's picking up on it a lot, and I think that's a problem for the defense. You have doctors, nurses, and they're all giving, we thought Munchausen by proxy, we thought CRPS, we treated here, we did this, we administered ketamine, we didn't. You have a lot of statements that are floating all over the place. And that makes sense because the entity is large. focus goes back to the larger questions here. The larger questions here. Let me go ahead and make sure I get to the ones that were specific to this particular witness, and then I'm going to go to today's. I do want to pull up Recovery Addict. You are too kind. Sir, you are supposed to be on a podcast. If you are here, then you are derelict in your duties to your podcast. I'm glad to see you that making the comment, though. Thank you for being here. And then there was also a comment here. Amy Downey, can Recovery Addict read books to me at bedtime? I would agree with that. Crazy Cat Queen, Recovery Addict is like having an interpreter at the UN. It was pretty incredible. So asking questions specific to this witness, because I will get to the rest of them. I have them starred. If you think I have not gotten them, I did get them. I did. Let me think here. Ms. Pete, I had med deliveries today, took your advice and listened to Recovery Addict for the first time. He was great. I didn't have to keep adjusting volume. LOL, thanks for all that you do. Learning lots. Me too. These trials are an opportunity for everyone to learn, not just you guys, me as well. I am learning a ton. Susan, thanks for being in the chat. Thanks for the contributions. I know you and I have some viewpoints that differ, but I love seeing the engagement. I was county hospital ER nurse, and if I documented every swear word, F word, C word, I was called, spit at, kicked at, I'd never have gone home. It wasn't even that big of a deal. That part rang very true to me. Susan, you're right. If a nurse in PICU or in ICU had to document every time a patient cursed at them, there's not enough pages in the world. I mean, what they go through and what the patient is going through in that moment that might cause the curse words. So, I mean, hell, this one, Cat P, thank you. I was hit by a car at 3 and I cussed at the driver with an IV, the doctor with the IV. I don't dispute that. I don't dispute that. A lot of people, solo YOLO, you have a lot of RNs in the chat disagreeing. That's okay. You can disagree. I'm not an RN. I don't know. Emma Daisy, I disagree, Rob. Sorry. If it was so out of the ordinary that she remembers it clearly to this day, as she said, and it's so out of the ordinary for a 10-year-old to act that way, you absolutely chart it. There you go. There's someone who's disagreeing with me. That's fine. I don't understand. I'm not pretending to be an expert here. I'm picking up on legal strategy and just kind of giving my commentary on what I'm observing. Carrie T, thank you, Rob, for the medical provider. I don't know how you put up with the nonsense you put up with half the time. So it's amazing. Let's see. Any other questions? Ava missed. I've come to believe that attorneys are actually underpaid. The time, mental energy it has to take to go through a trial. Oh my God, kudos to all the attorneys. You guys have there is no way for me to adequately explain. When we make the comment, or Emily makes the comment, we live here now. Attorneys are living this case day in, day out. There is nothing else. Mr. Anderson had his daughter's 12th birthday today, and he said yesterday he hasn't seen her in a long time. And I believe that. He's living this case right now. All of the attorneys are. They're not sleeping. They're eating like crap. They're probably losing weight like by the pound each day. You know what? I will bet you this. I don't think we're going to get any of the attorneys to actually agree to this. But if they stepped on a scale at the last day of this trial, I bet they each would have lost 5 to 10 pounds. It's what trial does. Okay. Morgan, thank you. I'm a critical care nurse in ICUs, and I've worked at Loyola, Lurie's, and Northwestern. We are advocates for our patients. Nurse Klein was hard to watch, listen to, body language. Interesting. There you go, Morgan. You're disagreeing with me. Interesting. All nurses talk in ICUs. It's our therapy to vent. And that part I agreed with. And I think I kind of made the comment about how the background noise influences every interaction you have with the patient. And maybe that bleeds in a whole lot more than what I'm giving it credit for, because I'm not there. So I imagine there's probably a lot of water cooler talk. I think we used to call it that. Is that still a thing? I don't know. Jules, do you think the defense has coached the witnesses to use fill-in words to use up more time on cross? I don't know. I don't think they've had the time to do that, to be honest. I don't know about that. OB nurse Chelsea says, I was annoyed. She said RN's job is to follow doctor's orders. It's a minimizing view of the RN. We have our own licenses and lots of autonomy depending on department. Second chat, if something goes wrong, I'm not off the hook just because I was following a doctor's orders. We have to advocate for our patients, and that sometimes means going against the doctor's orders. This isn't the 50s anymore. Interesting perspective. Interesting. Like I said, I learned during these cases too. Becca, why are we hearing about Maya using curse words now? Can plaintiff bring this up in rebuttal, assuming he has time for rebuttal? Probably. I think it was the timing was interesting. Whiskey Sour thinking my wife is Rob, my wife is a respiratory therapist. I asked her about compassion fatigue, and she said the business of healthcare sucks the humanity from the job. P.S. I apologize for oversharing the other night. You didn't overshare. This trial is taxing on everyone who is either watching, participating, engaging as a witness, or a viewer. You do not have to apologize for oversharing. And this observation about compassion fatigue, this is something that a lot of lawyers complain of too, is the business of this. When you engage in this practice, that it can sometimes bleed you of the humanity that you have. And that's why I tell people, go make something, do something to restore that in yourself. It is not easy. It is not easy. Creed M, I started this because I thought it was funny. Fun fact, the plaintiffs have less time per day for testimony than you do for recap at this point. That is 1,000% true. 1,000% true. Okay, let's go to today's testimony. Let me see here. Make sure that I've got what I need. Remove this one. You know what? What do I want to do, Rob? What do you want to do, Rob? What do you want to do? What's the call, Rob? You want to start at the end? You want to start at the beginning? I don't know, chat. What do you think? Shall we swoop and shall we debate it? Do we want to start at the end and go through the massive question that's in my head right now, or do we start at the beginning with where I was going to start with Detective Graham's testimony? So let me do this. I'm going to put up a little poll in the chat while I'm doing this. Start of today's coverage. Detective Graham to blog and I don't know what to say. Blog and law. Sure. The way I say it. Counts. It's really awkward. I hope you know what I mean. There was a lot of discussion at the end of the day that caused a whole lot of confusion. So I was going to explain that, and I don't know how I want to do it. But let's go ahead. One second, let me make a note real quick. Sorry for the silence, folks. Just gotta send messages here and there. All right. Let's do swoop. Double swoop. God, that's fun. Okay. So let's see here. Let's just check the poll real quick because I didn't give you guys a lot of time, but I think a lot of you are pretty active. Ooh, no, that's real close. I got to give you more time. So let's pull up some super chats while you guys have time to vote on where we go with this. Start from the beginning. Solo Yellow, today was fire. So anxious for your recap. Also with the hostile jury. It was a hostile jury. Marcia Barnick, you are our anchor, Rob. Curious about your response to what happened at the end of the trial today. You guys are conflicting me. Hostile jury or the end of trial? Where do I start? Where do I start? Hostile jury or end of trial? Bon seemed like plaintiff's attorney asked defense type questions during the direct on the witnesses to weaken the impact of defense questions. Was it worth it or wasted time? Wasted time. I think he could have gotten there with direct questions. I think you could have gotten there with direct questions. Baby steps 22. Please, for your health's sake, don't worry about doing F&F during the trial. We are here for you. Oh, we're doing one case for Friday Night Frenzy. One case, and it's a misbehaving Oklahoma judge that sent over 500 text messages while she was presiding over a second-degree murder trial. So it's one case. I probably, the thing is probably not going to be monetized on YouTube because I'm going to use profanity. But that's the one thing I want to cover. So it's going to be a shorter F&F tonight. I wanted that in the backup. Babs, thank you. You made it through another week successfully, and that should be celebrated. Thank you for your passionate dedication. Take care, Rob. Thank you very much, Babs. Matt Bond, well, hello, my spiffy, legal, mumbo, jumbo, talkie brother from another mother. How's it hanging? It is, we're still recovering. We are in the recovery mode. Ryan Man, YYC, everything I know about this trial, I learned here. Pretty sure that's enough. Thank you, Ryan Man. That's very kind of you. Drama Llama, can't sleep, but the upside is I can catch you live. Thanks for doing these and doing them so well. I hope you get to rest this weekend. Oh, this weekend is going to be sleep and then catch up on some legal work that I have to catch up on. Nicola Graham, hospital was presented with a tricky situation. Many have made think suspicious. What is the law, the standard the plaintiff has to prove? Do they need to prove the hospital had no doubt of child abuse? This jury, Nicola, we're going to get to that. That's the end of the day question. Matt Bond, we need to get Jules a shirt saying CRPS is like fries in ice cream. Nobody can work that shit out. Law and Lumber Crew. Thanks, Matt. I think we need a shirt that says this jury first. Linda Sue 62. I love the name. Rob, thank you so much for your time and recaps. Your channel has helped me understand more about the law and how the laws work in the courtroom. Thank you. Thank you. That is very kind. CE, if Jay Hatch was right, it makes their actions even more egregious and outrageous. If Maya was a victim, she deserved help and not humiliation, punishment and not ridicule. That was a thought process that I was having listening to a lot of the testimony today from the various doctors, which I'm not going to play on the recap. One, medically dense. I'm not a medical professional. That was a whole lot of stuff that was very confusing. I'm going to try and summarize it in as few words as I can. Two, the more I listened to the doctors go on and on, the more I started questioning, going, does any of this really matter for what I am seeing as the principal part of the plaintiff's case? And the more that I kept listening, the more I was going, no. And we got to the end of the day, and I'm sitting there scratching my head and just going, why are we here? Where are we? And now I'm kind of lost, and we all are. We all are. Even the judge is, until we get to Monday. So I want two parts to cover. For the afternoon, or for today's focus. And yeah, so I don't know. Morgan, Rob, please know we're grateful for your dedication. Hope you feel better soon. Thank you, Morgan. Very much appreciated. Aussie J, as an adult who has to explain my chronic leukemia every time I end up with a new GP or ER, I have to convince them of the treatment I need. I imagine the frustration. If it were my child, it'd be times a million. I know people who are afflicted with chronic leukemia, and I can tell you that they express similar frustrations. So I feel for you, and I'm sorry about that. Leanne Hokulani, I hate the stigma around international medical care. So many safe innovations outside the US. FDA is slow to approve and have financial incentive for big pharma. I'm not disagreeing with you. Outside the box, uncomfortable question. CRPS warrior here. Do you think, or chat think, that if the Kowalskis were open to alternative treatments other than ketamine, we wouldn't live here today? Appreciate you, Rob. The ketamine seems to have really been a driving factor in the hospital. And it's not just the ketamine, it's the insistence that be applied. So I don't know. Trial Watcher, so happy to have found you. Thanks for everything. Thanks to Lawyer You Know. Enjoying your recaps immensely. Thank you. Thank you. Morgan, nurse, Klink definitely got a report from the ER that came with more info. I covered that one earlier. Ms. Pete, I covered why, if the plaintiff has a deposition, don't show it. But if defendant does, why does it go against plaintiff's time? It doesn't. They are able to designate portions of any deposition. So when the defendants want to play a witness by deposition, the plaintiffs have the opportunity to say, well, we were there too. We want these sections included. And for the portions that they say we want included, that's charged against their time. It doesn't matter if it's the plaintiff's attorney asking the questions or defense attorney asking the questions. Whoever is behind the scenes saying, include this portion, this question, this answer, that person is charged for the time. See, are you going to comment later on Beata's email blog post from the end of the day? I am going to get there. Going to Chesney. Any way to bring in that memories change, believe speaking the truth, but it's not. That's possible, true. And I think some of the jury might think that way too, especially going over a case so many times. It's possible. It's possible indeed. Alicia, happy Friday, Rob. Happy Friday to you. Susan, thank you. Rob, is it possible? Rob, is it possible? Could be nervous and not a liar like all the other nurses. I told you what I thought. I gave you my thoughts that left their other patients' families' responsibilities to conspire against Maya at multiple hospitals. I told you my thoughts. I found her credible. People disagree. I'm okay with that. You can form different conclusions. I expressed mine. Emotional support paintbrush. How much can lawyers prep a witness? Burn time for us. They can, not really, not after trial's begun. There's a rule on witnesses that prevents that from happening. Christy McLaughlin, my case is not nearly as serious as Maya's. I have interstitial cystitis, which causes severe pain. An ER doc has told me I was faking the pain and that the ER is for real emergencies. It was devastating. You are not alone. A lot of people have expressed that frustration, and I think that's a big part of this trial and why people are interested in it. Susan, honestly, it depended on how busy it was. If I documented things like spitting, etc. I don't think a lot of chat realizes nurse can work 12 hours without a break. And yes, an ICU too. There's a reason you only have 2 patients. No, Susan, I told you, you don't have to fight with me. I mean, I'm not disagreeing with you on this one. What color shirt are they wearing? What are they? I get it. I understand. People on the jury might disagree. People might agree. I don't know. So let's see. How much money do you think Jay Hatch has spent in legal fees? Oh, we're in 6 figures. Easy right now. I would say probably $500,000. Probably. My Miracle Mama, with the obvious passion of some of the jury leaning towards plaintiff, do you foresee a hung jury? This could be a dumb question. Sorry. I don't know. They only have to reach a majority. So it's six that go back and they have to reach a majority conclusion. So I don't know. We'll see. At this point in time, we know the 6 that are going back. They actually chose that. That's public knowledge and information. So the 6 jurors that are going back, we're aware, like the public knows who they are. It's been reported that the 6 has been, it's been reported that 6 have already been selected. I don't know that we, the public, know which 6. I just know that 6 have been selected. So 6 go back, majority. If they can't reach it, they're hung. That's like unwinding a pretty complicated situation. Thank you, Azam, for being here. Very much appreciated. Erica, thank you for the very generous super chat. I have so many questions and comments that I want to make, but this is the one I think needs to be said. Thank you for doing these recaps. I look forward to them every day, and I enjoy listening to you talk and could literally listen to you all day. Erica, if I could talk all day, I would. Actually, that's false. I actually do talk all day. Just in different settings, different contexts. Usually it's to clients and courtrooms. but thank you for being here. And the fact that you guys want to listen to this case, the fact that you guys want to learn this with me is one of the reasons I keep doing the recaps. So thank you guys very, very much. It is incredible to see all of you here. Okay, let's go ahead and check the status of our poll. You guys, Detective Graham it is. Okay, Detective Graham. Here we go. Let's go ahead and go to Detective Graham. Make sure I have the volume tuned up on this one because it was low on the other. Low on another. Where is our good detective, Detective Graham? Now, remember when I told you guys about biases and things that we bring to the table? This is where I confess a certain bias. And what it is, it's not a bias for or against, but I know too much about law enforcement interaction, for me to just not bring that into my commentary. So that's a little bit of a forewarning here. So before we swoop, I'm letting you know that I know too much about law enforcement commentary or law enforcement interaction to not bring that to the table. Okay. So that was your swoop warning.
9th, end of the trial. And whether that's the time that you're going to begin to deliberate, or would that include the deliberation days?
Look at the camera focusing on you. There you go.
I anticipate, and I
Get away from
think
Jack.
on once,
Stephanie Duane.
Guys, I'm going to push the beginning of FNF to 10 because there's no way I can make it through the legal and this. I have to push the beginning of FNF to 10. I apologize for those of you waiting, but I need to make sure I get through this.
I-
Okay, I'm just sorry. I see this.
Okay.
May it please the court. Good morning and happy Friday.
Good morning.
Okay. Would you introduce yourself to the jury, please?
Hi, I'm Stephanie Graham.
Ms. Graham, will you give this jury the benefit of your background and well, let me just set the table first. We're going to talk to you about some involvement in this case, in the Kowalski case, in October, November of 2016. Okay.
Yes.
Can you tell the jury what was your occupation at that time?
I was a detective with the Sarasota County Sheriff's Office.
Okay. Now we're going to work backwards. Okay. Can you tell the jury, starting with college, where did you go to school?
I graduated from University of South Florida with a Bachelor in Arts in Criminology. From there, I went to the Sarasota Criminal Justice Academy, where I graduated first in my class in 1998 and subsequently was hired by the Sarasota County Sheriff's Office.
Okay. Did you go to the Sarasota County Sheriff's Office right out of, I think you said it was detective school or officer school? Criminal Justice.
Criminal Justice Academy. Within about a couple weeks, my hiring process, I believe, had started prior to my graduation from the academy. And then I was hired April 30th of 1998 because I just retired this past May.
So we're bringing you back. We're going to put you through a little memory contest. But so once you finished the academy and you had the job at the sheriff's office and that time period, what did you do for the first years? What types of roles?
Okay, so during my 25 years with the Sarasota County Sheriff's Office, I had the privilege of working in several different areas. One being a court.
Do you recall during your conversations with Mr. Kowalski whether he made other statements to you regarding his?
Hang on, I want to get the recordings. So the recordings are the big thing. There was an interview of Jack Kowalski in the hospital, and she was brought in after DC had no contact. Here you go. The recordings are the issue here.
I mean, when we were in the meeting,
That's the recordings are the issue.
Conversation that had taken place where he had expressed his consent for the child to be treated.
Your Honor, I'd like to publish to the jury what's been previously marked into identification as defense exhibit 3121A.
Yes.
I mean, when we were in the meeting, with the doctors one day, and the other one said, Maya, I'll sign her out, and I said, hold on, time out. And that this wasn't in, wasn't written down, which I was kind of mad about, but, I asked the doctors, I said, what's the time frame you're talking about? And they explained, I said, that's doable. And was my wife happy with what I said? No, absolutely not. So you have to, there's times I'm gonna go the other way.
Okay. And thanks for sharing that.
I don't know why they didn't write that down.
Was this a theme of your conversation with Mr. Kowalski where he was expressing to you that he was supportive of having Maya treated at our Children's?
Yes, that did come up.
On that question was sustained the,
Do you recall during your conversations with Mr. Kowalski whether he made other statements to you regarding his either consent or lack of consent at keeping Maya at all Children's?
That's my recollection, but I might need to. That's my recollection, but I would probably need to refer to the transcript to know specifically what those statements were when they occurred in the conversation.
Let me add context. Shapiro has to lead here. The judge is kind of instructed and given a little bit of leeway. He has to lead here because this is so close to the Chapter 39 immunity issues and the DCF investigation. Shapiro has to be careful with the questions. So the judge is going to give him leeway to leading the witness down the road because the judge doesn't want the witness saying something in an open-ended question that could bring a mistrial. So that's why you will hear a lot more leading. So the judge is going to give him some rope.
Okay. Your Honor, I'd like to publish into evidence, publish to the jury what's been previously marked as 3121B.
My bigger question is, why would a parent go to these extremes?
Because I'm told this is the last resort.
But you're saying it's not. And this is not, I mean, also what I'm taking was a question from you somewhere along the line that are we doing the right thing? Maybe we should go back and talk to another doctor, do something more conventional, not something that's likely to kill her.
I'm effective of keeping her here. That's what I told you. And if they think something else, I'm supportive of keeping her here and looking.
Detective Graham, having heard that audio, does that refresh your recollection as to the conversation that you were having with Mr. Kowalski?
Yes, it does.
Was there a time during the conversation that you had with Mr. Kowalski where he indicated to you any concerns with Mrs. Kowalski's behavior?
Yes.
Okay, and what types of concerns was he expressing to you?
She wasn't being cooperative with the things that were being requested. He stated he was appalled by some of her behavior.
Your Honor, I'd like to publish to the jury what's in evidence as 3121C.
But it's just, your wife's behavior is very concerning to me.
Sure, and it's getting worse right now. Just, she don't want to cooperate.
Along those lines, Detective Graham, did Mr. Kowalski discuss with you during this time that any concerns he had with Mrs. Kowalski following the rules?
He'd expressed there had been some interference on her part with him trying to communicate with Maya, yes.
Your Honor, I would like to publish to the jury what's been received into evidence as 3121D.
Because I know Mom talked to her once, and that was supervisor, and I guess she got shut down many times because she was falling off.
She could.
And then she told me what she said. I said, you can't do that. Don't talk about medical stuff. Why are you talking about the lawyer? Why are you doing?
Why can't she control her? If her daughter is her main priority and why can't she follow the rules and do what she's being told to do?
During your conversation with Mr. Kowalski, do you remember any conversations with him about him noticing any differences in Maya's behavior, whether he was present or Mom was present?
Yes, he expressed that there were times he would be home alone and there would be no complaints of pain or discomfort. And when the mother would come home, the child would immediately be in pain.
Your Honor, I'd like to publish to the jury what's been received into evidence. As 3121I.
When nobody else was in the room but Maya and the staff, she didn't have to completely normal. When Mom would walk in the room, she's insane.
I heard that many times.
There's no other explanation for that.
Yeah, I noticed it too with myself being home, and then Mom comes home from work.
And all of a sudden she's back.
So
you're at home, your guys are doing well, they're playing.
no complaints about me.
No complaints
But
about
then when Mom gets home,
She's
maybe-
okay.
During your conversation with Mr. Kowalski, did he express to you any of his intentions in terms of his home living situation with his wife if Maya were to come home?
Yes, he had offered to me that given the opportunity to bring Maya home, that he would have the auto move out.
If I could publish to the jury what's been received into evidence as 3121G.
I thought you were going to answer the question if Maya was released from here and she was going to be brought back home, if I would have had my wife move out.
That's my next question.
That would be absolutely on our feet.
One moment.
did that series of questions, and that evidence, did that help the hospital? This is a judgment call on the part of the hospital as far as whether to play that. So for those of you in the chat asking, did she alert him that she was recording? And isn't Florida two-party consent state? Law enforcement's allowed to record regardless of they're allowed to record regardless of consent in this state. The judge makes a ruling on that. That's not me advising, that's me corroborating the judge's ruling. So she's not required to inform him that she is recording. Now she does, but she starts the recording late, so you miss the beginning of the conversation. She does testify that she is wearing her firearm, she's wearing her sidearm, and that this is couched as an interview. Now, that was kind of my question. Does the playing of those recordings help the hospital? Me, and I have told you already my biases. I have laid them out on the table. I have expressed them openly and honestly. To me, that was the detective placing words in Jack's mouth, forcing him in a position where he had to answer the questions in the way that she wanted, or else the investigation or interrogation would continue. I think Jack would have said just about damn near anything to end that interrogation. And that's the problem that a lot of people end up in when they're talking to law enforcement, which is why I told you about my biases. Law enforcement is trained to get these answers out of you. They are trained to get those responses. The accusatory tone, all of that. This is, I mean, if you're a father and your daughter is in the intensive care unit and you disagree with the tactics that your wife is engaging in, I mean, the back and forth, the dialogue, the explosive conduct, listen to me. I am one of those people where there's a confrontation at a bar. I'm the person that walks over and smooths it over. I'm not the person that says, you go and you do that and you keep fighting. You fight the good fight. No, I like to de-escalate. That's my gut. That's what I go to. So yes, if someone came to me and said, look, this person over here to your left is being a really big pain in the ass, don't you think they should cool it? I'd be like, yeah, I think they should cool it. But it doesn't mean I don't like the person or don't care for the person. I think they should cool it. And then the testimony about you testified that you would have her leave the house in order for Maya to come home. You're damn right I would agree to that if it got my daughter out of the hospital. I have expressed my biases. I have told you beforehand. I don't know if you, it's okay if you disagree with me. That's fine. I have expressed where my inclination is. Now, a lot of my, wait, hang on. Oh, a lot of my biases come and they get kind of inflamed during some of the cross-examination. So we got the bulk of the testimony out of her direct. So let's go and see if we can't find cross. Oh, there we go. The approach.
And speak.
You were given a private room
Wait.
because
Dang it. Now, this is a witness that Anderson needs to spend some time on.
a month after this.
Thank you. I don't have any other questions this time around.
Anderson needs to shred this witness. He needs to.
I do have questions. There is a
That's an objectionable remark.
there is a technique that and were you a detective at this time?
I said I was, yes.
And how long after that were you a detective before you moved to another position?
I became a member of the civil unit, I believe, in November of 2017.
So what, about a month after this?
No, November of 2017.
About a year after this?
Yes.
You were no longer a detective.
No, I had chosen to leave that unit.
Yeah, but at this point, you were a detective. Now, there's a technique that detectives use when they're trying to get a confession or something out of someone, and that's called flipping the accomplice. Is that not true?
I would assume so, yes. I've not heard that term referred to.
What do you refer to it as?
As doing an interview.
Well, it's a little more than an interview, is it not?
I'm not sure I understand your question.
Is it not for the purpose of getting one person that you perceive as part of the crime to testify against the other?
That can be, yes.
Right. And to do that, what you do usually is use threats of prosecution of the person you want to talk, right?
That could be possible, yes.
All right. So now, for instance, like here, like threatening Jack to let him know that you had put a father away for 10 years before, right?
I told him that, but I think that was out of context.
Side note, I love the little accent he throws on the right. Yes. Tell the witness that this is a yes or no question and I know the answer. Right?
It wasn't meant to be in that the way you're referring to it as.
Just how far out of context can it be to tell someone in Jack Kowalski's position, with you there in that room with a badge and a gun, that you would put somebody else away for 10 years impliedly for this?
My recollection of explaining that circumstance to him was that the parents thought they were doing the correct thing at the time they committed the crime and loved their child and had the outcome was not necessarily what they intended, but that there was a punishment for that. That is my recollection of the reasoning why I brought that case up.
You were reminding him that even though he loved his child, he was doing the right thing, he might in fact end up spending 10 years behind bars. That was the purpose.
I was explaining to him that even a loving parent thinking they're doing the right thing, not knowing what the end result could be punished for their actions. Yes.
I noticed that you used a couple times the phrase, the opportunity to, as in the opportunity to meet. Do you recall that? Your testimony right here in front of the jury just a couple minutes ago.
If you're saying that's what I said, I don't remember using those exact words, but
Right,
if you're saying, that's fine.
They're taking notes. And also the opportunity to speak privately, right?
Yes.
Okay. But that's not exactly the way it went down, is it?
Is that a question?
Okay. That wasn't the way it went down, was it?
I asked if we could speak privately. We were given a private room to sit down and speak.
You were given a private room because the hospital knew you were coming, obviously, right?
So the question that drew the objection was the hospital knew you were coming. That is Anderson walking a fine line. That is getting into what initiated the call. And if it's like a CPS investigation, and that's starting to get into that Chapter 39 issue. So Shapiro was like, I'm going to object prematurely because I know where he's going. That was what Shapiro did. Shapiro goes, I'm objection. That question itself wasn't objectionable. But Shapiro had to make the objection early to get up in front of the judge and say, this is where he's going. And he asked the judge, get him to reorient. And the judge agrees. The judge sees where Anderson's going. The judge says, Anderson, reorient. So it was that question and that response was that's lawyers going back and forth. Shapiro's good. He's growing on me as far as how he's very good at arguing. I don't know about his witness interaction, but his argument and how quick he is with objections, I think he's good. Oh, there's Jules behind Jack. Hey, Jules, I see you. Let's get beyond this and see if we can't find our way back to some of the commentary. I know you guys hate Shapiro. I like the trial practice. That's what I appreciate is the litigation. So get it. I mean, Anderson was sarcastic as hell with the last witness anyway. So was Shapiro with the other ones. It's styles. They're just styles. Long sidebar. Like I said.
Sally Smith, had you not?
Yeah.
I don't recall talking to Sally. I don't recall talking to Sally Smith specifically about coming to the hospital.
Was she or was she not the main source of your information about this?
I'm okay if you want to go there.
That question you can ask, but
Dr. Sally Smith was the main source for the medical information.
I told you that was the redirection. Like the judge was like, you can walk this line, but walk it carefully.
Information I was receiving. The custody and DCF side and family court side was through the Department of Children and Families and supervised visitation.
So now, relying heavily on Sally Smith's information, you went to the hospital, and who did you meet there?
Just to clarify, the information I received from DCF and Sally Smith was why I went to the hospital.
The witness is so well. She wants to throw the word DCF in as many times as possible. Good coaching by the defense, by the way. Good coaching. Got to tip the hat to that. DCF is going to repeat over and over again until the judge kind of makes it clear we're not going there.
I probably had contacted someone with the hospital to facilitate getting us a room where we could speak privately.
Okay. And then Kathy Beatty met you at some point from the time you came into the lobby to the time you got on the elevator to go up to the PICU, correct?
That's my recollection, is that she's the one who facilitated getting the room.
Right. So you and Miss Beatty rode up in the elevator, right?
I would assume so, yeah.
Yeah. And were you in uniform at that time? No, you were plain clothes.
Plain clothes.
But you did have your badge displayed.
I did.
And you had a gun.
Likely,
displayed.
yes.
Well, what kind of gun? A Glock? What was it?
6 hour.
A 6 hour. Okay. And so when the doors opened, were Jack and Maya standing there?
I
as
don't
you came
specifically
off?
recall that.
And in fact, the first time then, whether they were standing right there or close there too, the first time that they saw you would be with Miss Beatty, correct?
That's possible.
Right. And you got some information about this situation from Miss Beatty too. Am I true?
I had been in contact with Ms. Beatty as again, facilitating some information about.
And you'd worked with Ms. Smith, Sally Smith, Dr. Smith, excuse me. Previous.
Another approach. Here we go. We are so in the DCF. They are. It is DCF, and this has more landmines than the beach at Normandy. Thank you, Attorney Hunter. I needed that in my life, and I appreciate the fact that you gave me that objection. Your Honor, this has more landmines than the beaches at Normandy. That is now my favorite new objection. I need to make a shirt that says that at some point in time, because my word.
You were getting off the elevator with Miss Beatty, were you not?
Hang on. There we go. Oh, the jury question about motor separated.
With Miss Beatty. When we left off, you were getting off the elevator with Miss Beatty, were you not?
That sounds reasonable, yes.
Yeah. And then the hospital or someone provided a room for you. Is that right?
Yes.
And you sat down on one side of a table, a relatively small table, was it not?
I don't recall, but there was a table, yes.
Like it wasn't a gigantic conference room table. This was,
No, my recollection is like a small family waiting room.
okay, small family radio.
Or not small, but. You know.
And were you positioned such that Jack went in first and then you sat down between Mr. Kowalski and the door?
I don't recall where I sat specifically.
Okay.
Oh, Jessica, I agree.
Then you had a badge and a gun sitting with Mr. Kowalski in a visitor room, right?
Yes.
And you told him you were going to ask him some questions, did you not?
I asked if we could talk, yes.
And one thing you did not say at the start was, oh, and I'm going to be recording you.
No, I
Did
didn't.
you? And in fact, your phone that you recorded it on was on your purse, kind of half in and half out of your purse sitting next to you.
Generally, if I've done hundreds of recorded interviews, it is either on the table, and sometimes, yes, it might be in my bag. That specific day, based on the recording's clarity, I had reason to believe that it was on the table.
Okay. And so
Do you know what she didn't say? Do you know what she didn't say? All of the other parts of her explanations, all the other parts, I recall, I remember. You know what she just said right there? Based on the clarity of the recording, I have reason to believe it was on the table. I would have heard that answer and gone to the mat on that answer. I would have questioned and said, so you can recall everything else. You can recall where they were standing, who you were with, what you were doing. You can recall the discussion. You can recall making the recordings. You testified to the jury emphatically about the recordings and what you were trying to elicit from the person you were interviewing. You can recall all of these different things. But when I ask you the question of, was your phone in your bag or on the table? Your answer to me was, based on the quality of the recording, I have reason to believe it was on the table. I am 1000% calling bullshit on that answer. I am calling bullshit on that answer. That is also my bias, which is informed by my experience of how law enforcement likes to testify. I love law enforcement. I do. But I know how they testify. That question, of all of the ones that she answered, that was the one where she said, I have reason to believe.
So Jack Kowalski, for the most of this conversation, did not know you were recording him.
He didn't. The
And-
recording states that there was some conversation prior to the recording starting.
Mhm.
I don't recall telling him, but there is no right to privacy when you're talking to the police. I can record conversations as part of any criminal investigation.
Well, you knew
He's
he was
correct.
represented.
It would have been better if you had just led with that. If you lead with that, if you go in the open with that, I didn't have to tell him I was recording. I did it surreptitiously because people tend to say that they tend to recount or restate, or when I go to write my report, they might go back and say I was lying. Lead with that. Lead with it. The jury will excuse you for surreptitiously recording in your capacity as law enforcement. What they won't excuse you from is saying that you did tell him you were recording and that you did have it on the table, but then going back to, just in case you don't believe me, I have the right to do it anyways. That two-step right there. Anderson nailed this cross.
By counsel, did you not?
I was not aware he was represented in any criminal matter.
Well,
Oh, I'm going to be so angry. I am so
knew
angry.
he-
Hang on. I'm so angry right now. I apologize. This is going to make me blow my top.
Recording states that there was some conversation prior to the recording starting.
Mhm.
I don't recall telling him, but there is no right to privacy when you're talking to the police. I can record conversations as part of any criminal investigation.
Well, you knew he was represented by counsel, did you not?
I was not aware he was represented in any criminal matter.
Well, you knew.
Are you? Is it 2 hours yet? I don't care. Are you fucking kidding me? Are you fucking kidding me? I was not aware he was represented in any criminal matter, but you knew he had counsel. You knew he had counsel. Did you ask him or advise him that he might wish to speak to his attorney because this was an interview that might be used against him? Now, you don't have to do this. This is law enforcement playing a game with the rules. This is permissible. This is allowed under our system. But there is retired law enforcement on this jury who knows the rules. And Tara Rayner makes a really good point. He didn't know there was a criminal matter. You knew he had an attorney. You put him in the room. Oh, I know, uncivil. I know. And that, I was saying, non-custodial means no Miranda. I agree. There's debates on whether this was a custodial interrogation because he was in a room separately. She had a firearm and the door was technically open, but there was implications. This was skirting. This was literally walking Miranda. This was walking that line and saying, we're going to go and do everything on the inside of this line, just right inside. Oh my God. You knew he had an attorney. I don't care if this is proper. This is going to piss the jury off. This is going to make the jury mad. If you are a juror who
He
has
was being
any understanding
represented
of law
in the
enforcement,
matter
yes.
involving his daughter there at Johns Hopkins. Did you not?
He talked about being represented. We actually discussed his attorney. He never specified that he wanted to speak to his attorney, but that was the attorney representing him in family court.
Did you ever then tell him he had the right to counsel at that point?
I'm not required to.
See, because you don't believe you had him in custody yet?
I know I did not have him in custody.
And at that point, you hadn't even found a reasonable suspicion. Is that right?
I had a DCF report. I had a medical staff with
DCF?
child protection team voicing concerns about the health and well-being of this child, with the concerns focused on the mother and her inappropriate behavior. And yes, I did have a reasonable suspicion to go and speak to him to find out what his opinion or basis was in this matter. That's what an investigation entails.
Well, would it be true that you at this point were not comfortable saying there's hang on 1 second.
All right, Anderson does a good job. This is him shredding this witness. Shredding. Annihilation. So, oh, thank you. So a very good friend of mine, now I'm calling him a good friend of mine, because when we went to the jury questions, we're going to bring the jury here. We're going to bring the jury. We're going to bring the jury. Guys, I'm going to do FNF tonight. If I have to push it to 10:30, I will. I'm going to do FNF tonight. It's a quick story. It's going to be like an hour. I promise you, it's going to be quick. It's going to be quick. So even if I have to push it to 10:30, I'm just going to roll into that stream, okay? We're going to bring the jury. Emily, where are you? Emily, I need you.
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
So, returning to the stream by popular demand is Recovery Addict. Because we have jury questions. The jury questions, the jury gets up, moves out of the room, and now we are back to a situation where it's like, oh shit. So returning to the stream by popular demand is Recovery Addict giving us a breakdown of what was said during this sidebar where the judge mutes
I
himself.
had had on red number 1, an objection to the first question.
Yes, Your Honor.
Yeah, I do agree. The court can probably give you instruction.
Oh no. Okay. She asked if he showed Jack the gun. Did he tell him the consequences if she did not speak to you? So if you were out of his jurisdiction, why were you?
Sir, the fact that you picked up on the fact that he muted that quickly and started immediately saying it, I know the Zoom is like 5 seconds ahead. My God, that's amazing.
In interviewing him? No objection to that. Okay, I'm just verbatim. I'm going to repeat what I hear. Judge says, red number 2. Did Jack inform you of his service? Number 2, did he demonstrate from that service that he possessed a knowledge of his rights as they pertained to your interview and his lack of requirement to participate? And there's a 4th and a 5th, which I couldn't hear that. Did he mention his legal counsel? In your experience,
I like the fact that like me looking at the screen, like looking at where he's talking from is actually like I'm looking at him right now. We're hanging out. We're broing out right now.
do leaders of quotes, police, parallel services, I assume it's parallel, end quote, paramedic, usually have more or less knowledge of their civic rights than average citizens? Did Jack demonstrate any nonverbal behaviors that made you feel the discussion was not wanted? Yeah. Anderson says, I don't know if she's going to have knowledge of all that, but I'm fair. No objection from the defense. It says Mr. Shapiro, no objections from me. Shapiro says that was a question, not a statement. Judge says, red number 3. At what point does the police and CPS think it is a good idea to take a 9 or 10-year-old child from parents with when the judges, I'm not sure, when they think, I'm not sure what those last few words are.
That's a lot of objections.
Her parents must be her parents. Shapiro says, interesting question, but calls for legal conclusion way outside her scope of knowledge, so I'll have to object. It's also some Chapter 39 issues. Judge says, I sustain in that question. That will not be asked. Red number 3.
Yes, not
Red number, that was red number 3. Red number 4. Listening to your recorded interrogation, you testified that you informed Jack you wanted to talk with him. From what I heard, your talking made me feel very uncomfortable. This won't go in. Abe, it says Abe. There's a word Judge can't read. This juror, knowing police tactics, must ask, where were you there to, quote, get to?
He prefaces it with this juror, comma, knowing police tactics, end comma. Continuing with the question.
A anticipated conclusion, end quote, or to, quote, seek the truth. Judge says there are a couple words I'm having difficulty with. I think that was our law enforcement juror. Shapiro says, I don't have a problem with the actual question asked, which is, were you there to get an anticipated conclusion or there to seek the truth? But I object to the preamble that starts with what you testified to and specifically the statement of, quote, from what I heard, your talking made me feel uncomfortable. Mr. Anderson says, I'm okay with the from. I think the first two probably should not be there. I think from the defense's restraint, Shapiro steps on and says, the only question, I don't have an objection to the actual question being asked, just the preamble. Judge says, so you want me to start, were you there to, quote, get to? Judge says, I'm not exactly sure what that word is. Shapiro says, were you there to get to an anticipated conclusion? Both sides agree that that's what it says. Mr. Shapiro says, I don't have an objection to that. Judge says, so I will not do the preamble, but we'll start with that question. Red number 5. All police departments keep statistics while working in this unit to protect the vulnerable of society. What was your case ratio of successful prosecuted cases versus lost? Is there an objection? Yeah. Judge says, I agree that's an improper question, won't be asked. Red number 6. Did you inform Jack the reason for the interview? You said it was probably your iPhone that you recorded it. Interrogation of Jack. Where was your phone during the interrogation? Was Jack given the notice that the meeting was being recorded or to refuse the recording of the interrogation? Does the recording of the interrogation
That's
have a
LEO.
recorder opening with names, dates, location, and consent to record? That's a yes or no. If no, is it your usual modus operandi
That's LEO.
to record interrogations without the knowledge of the interviewee? Old school, as an officer doing their job, will get complaints. In your stint as law enforcement, how many oral or written complaints were found in your personnel file? Shapiro says, we object to the entire thing's beyond argumentative.
The juror just asked about complaints in her personnel file. Oh my God.
If we're highly concerned with what's going on, this animosity is coming from one. Well, I don't say one, but Mr. Hunter says that one with number 1 on it indicates a high level of bias and prejudgment. Shapiro says it's a different issue, but we're noting that for the record, but we object to the entire question. Mr. Anderson says, that's a fair question. Did you inform? I think they're fine. Did you inform Jack for the reason for the interview was fine? That one's coming in. No objection from Shapiro on that. The judge says, you said it was probably your iPhone that you recorded your interrogation of Jack. Where was your phone during the interrogation? No objection to that, says Shapiro. Judge says, was Jack given the notice the meeting was being recorded?
What's cool is you can actually see, if you actually watch the screen, you can see it. It's almost real time. You can actually see
the recording of the interrogation. No objection. Judge says, this yes, the juror asked for a yes or no. Does the recording of the interrogation have a recorded opening, names, dates, location, and consent to record? Shapiro says, I don't have an objection to the question, but I have an objection to the juror insisting that that be a yes or no question. I mean, if the answer probably is yes or no, but Judge says, well, they don't know. At the end of the day, you get the opportunity to follow up. That's fine, says the judge. And then the next question, if no, is it your usual modus operandi to record interrogations without the knowledge of the interviewee? That's fine, that's coming in. And then I'm assuming the old school comment is not being asked. Shapiro says, we object to that. Okay. Next question. What is the extent, this is red 7, what is the extent of your medical training? What's the extent of your
this is
psychological
Elio.
training at that time, 2016? How much did you know about CRPS? Do you know now what the acronym CRPS stands for? Shapiro says, we object. That's far outside the witness's scope of practice. Should not call for medical interpretation. And this is going to blow the door wide open to how she got her knowledge, what the treatments were, and what was being pursued.
I think number 7, these questions, I think these questions are, so we know for a fact that there's a retired LEO, law enforcement officer, on the jury. I also know we know for a fact, based on prior questions asked, that there is a retired person from the medical profession. So those 2 individuals are on the jury. Those are our hot mic jurors.
The DCF investigation, just noted for the record, without investigation, all this hostility seems to be coming from the same jurors. Judge says, time out, one at a time. Mr. Anderson, he says, I don't see a problem with asking about the medical training. We don't know the basis for that. As to the remainder of them, I'll join with counsel. So he's going to object as well. Shapiro says, we object to the first one. She's come to us as law enforcement. She was specifically advised by both parties to not get into what she knows, her training, and she was, so we object to her being interrogated because this is going to open the door for her to say, well, I don't have medical training I relied on. We'll direct you to Maya's presentation. I can't hear this part. Too many people are talking. The judge says, okay, we already have a disagreement between plaintiff and defense. We shouldn't have disagreement between the plaintiff itself. So that's Mr. Whitney that was chiming in. The first question the judge says, I think is fine. Shapiro says, would I be admitted to cross or redirect her on why she thought there was medical child abuse, despite the lack of her training, because it implies that she had no basis for investigation because she doesn't understand the nature of the disease. And she had 285-page file with medical reports in there from Dr. Lewis. This is the problem with this question. They didn't call her for this basis, and now, to unfortunately, hostile jury, we're ripping a door open that we tried to close. Judge says, I disagree with the concept that these questions are hostile. What is the extent of your medical? I don't see how that's a hostile question. What's the extent of your psychological training? I think those are basic questions. Now, Mr. Shapiro, you've convinced me that this question should not be asked because of what comes behind it. So I will not allow those questions on red number 7, including the medical training. So these questions are not coming in. Red 7's all questions are out. Red number 8. If you are to investigate abuses against society's most vulnerable, and in this case, Maya was most vulnerable, Jack, Beata, Maya were part of this case. Did you not feel compelled to interview all involved? Or you did not feel compelled?
That is almost every juror. So you have 4 or 5 different jurors right now who are slaughtering this witness. This is why I say, Anderson, stand up, sit down. Anderson, wave at the witness and sit down.
Shapiro says, again, noting for the record, hostility and argumentative questions coming from a single juror, and all this would be, the questions from the jury need to be, judge says, the question from this jury is, why didn't you interview everybody? Which I don't see how that could be hostile. Shapiro goes on, that actual question, that predicate is hostile. Judge says, hold on a second. And we lost audio.
All right, so the judge gets wind that, I mean, this is now a back and forth. This is now a back and forth. And I'm getting notes that my audio is delayed. Hang on one sec. I'm gonna try and switch my. No audio. Is there audio? Audio testing of the audio. Do we have audio? Do we have audio? I think we have audio. Yay. I'm yelling on the inside. I'm yelling on the inside. I know that I'm live. I know I'm talking to you guys. I'm pulling up links. I'm pulling up the areas and trying to find where it was that we left off. Fun. We call this fun. Oh. Okay. Here we are. Back to day 20. Let's find our timestamps, Rob. That wasn't just like a squirrel. That was the squirrels chewing through the wires that. Oh, that's really frustrating. And now none of the. Right now, I can't hear anything. Can't. Give me 2 seconds, folks. Give me 2 seconds. Here we go. This is how much of professionals we are, is that was a full on computer, like computer just crashed. It just said, nope, not doing it. Just said, nope, we don't live here anymore. We don't live here now. My computer said, we no longer live here. So look, we're back. We're back. And because we're professionals and because we have the jury,
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
okay. So before we get into this, let's go ahead and talk about this. The concept of the hostile jury. A lot of debate back and forth during that sidebar. Hostile jury. What does that mean? Is that objectionable? Do we have the ability to basically say mistrial because hostile jury? The short answer is no. No. The jury has done nothing improper. There was voir dire in this case, which means that they had the opportunity to ask questions of the jurors before they were impaneled. I made the comment yesterday, the person who selected this jury is either a genius or an idiot, depending on what side you're on. If the jury lied, if one of those jurors lied, for example, one of the questions we always ask of a jury, are you former law enforcement? Routine question. If it's a med mal case, do you have experience in the medical professions? Routine question. And then it's a judgment where you're weighing of whether or not to keep them on. So this is a question where no, you're not getting the jury dismissed. You're not. The hostile jury thing, Your Honor, we object because the jury is hostile. Okay. All right. What would you like me to do about it? They're hostile. They don't like the evidence that's been presented thus far. It's your job to re-navigate or reorient those sales. Now, Mr. Shapiro, if you have evidence that the jury is communicating with one another, if they're deliberating behind the scenes, if they're coordinating questions, that's a different story. If they're doing that stuff, then yes, that's improper. They shouldn't be doing that stuff. But just to say they're hostile, no, you can't. I imagine Shapiro's looking at case law saying, can I do this? Heck, if I was him, I would be too. But just to say the jury is hostile, I'd like an instruction that the jury not be hostile. No, that's why we have the sidebars to go over the questions. That's what the judge just did. He brought you up there and he said, what parts of these questions are okay? When people have asked me about, is it okay the jury's asking questions? When I had previously commented about juror questions and how I was apprehensive about it, it was with the understanding that I didn't know what the jury was going to ask. This sidebar situation allows the attorneys to kind of navigate and reorient the questions and say what's fair game and what's not fair game based on the evidentiary standards that we have and based on the information already in the record. So you'll understand that a lot of the questions that are being discussed at sidebar, the objections you hear are the same objections you hear in court: argumentative, leading, hearsay, outside the scope, stuff like that. So no, there's nothing wrong with the questions. Anyways, let's get to those questions. After we hit the panic button and had to restart the whole damn stream. You guys stress, man. Stress. Celine. I mean, Mike, 1 point. Computer, 1 point. Jarvis, 1 point. Mods, 30
Well, you did
points.
not
Spinning
discuss this
wheel,
case amongst
8.
yourselves. You did no investigation. You did not receive any information about this case. Is that correct?
That's correct.
And has anyone approached you about this case since you were gone? And have you seen any media coverage?
No.
And this witness was out of our presence when I spoke with the lawyers. And so, ma'am, I've got some questions from the jury for you. And just as a reminder, you will have all of what's actually in evidence with you, but you won't have what is not in evidence. Did you show Jack that you were carrying a gun?
It would be normal for me to be wearing my badge and my gun on a daily basis when I'm at work. Yes.
The next part of that question, was he aware you had your gun with you?
It would have been holstered on my hip as part of my uniform that I wear every day during every investigation.
Do you remember if you gave Jack your business card before or after you met with him?
At the very beginning of the conversation, he requested my card and I offered it to him, and that was recorded.
When you say this conversation was voluntary, did you tell Jack there would be consequences if he did not speak to you?
No, I would not tell someone that. He was under no obligation whatsoever to talk to me.
If you were out of your jurisdiction, why were you interviewing?
Every normal human knows that's bullshit. Every normal human knows that answer is bullshit. They know they're under no obligation to talk to me. Cop says, hey, you want to talk for a second? Completely voluntary. You can leave anytime you want. Now, the implications of you leaving at this point in time in our discussion is that I don't have your side of the story, which means I only have what they tell me. And what they tell me might be enough for me to detain you. So if you want to tell me your side, yes, you can leave. There's the door. It's right over there. You can leave anytime. But if you want to tell me your side, that might persuade me not to listen to their side. And then, we can find a compromise where I don't arrest you. Oh, so you're staying voluntarily. And you'll speak with me voluntarily? Are you sure? This is voluntary? 100%. You're not being persuaded or intimidated in any fashion, as I have my badge and my gun, and we're in a room where I did the snappy finger and said, come talk to me for a second. Cool. You have an attorney. Is that attorney retained in a criminal matter? No, they're just your attorney in the DCF case. That's fine. We can chat. No problem. No problem at all. By the way, this is me admitting my biases. This is me admitting my biases. I've seen too many of these things to know what transpires.
Because we were contacted by the DCF office in Sarasota County, and a family lived within Sarasota County.
Hang on. I want to call this up for a second. Giuseppe, Rob, it's a court Zoom, not meant for public. You are right and wrong at the same time. You are not allowed to rebroadcast the actual feed. You are not allowed to rebroadcast the actual feed. You are 1000% allowed to report in real time and live what is being said on that feed. That is 100% permissible. There's nothing wrong with what Recovery Addict has been doing. It has been a remarkable service. When the judge wants to mute, the judge does. That last sidebar got muted because discussions got too in the weeds. But everything about this case is public. The sidebars are public. When the transcription occurs with the eventual appeal, we will get transcripts are going to be there for every sidebar discussion. Every word that's said is public information and knowledge. So the listening to the Zoom feed and saying out loud what's being said in court, 1000% permissible. That's allowed. It's clear as day. It's allowed.
Jurisdiction, and that's why I was instructed and got involved. It would not be unusual for me to go to All Children's Hospital if the child was transported there and something had occurred in Sarasota County.
Did Jack inform you of his service?
Can you?
I assume that means of his fire department service.
He told me he was retired. I don't recall exactly retired from what, but he made a comment that he was a medic.
Did he demonstrate from that service that he possessed a knowledge of his rights as they pertain to your interview and his lack of requirement to participate?
There was no discussion about that.
I'm sorry.
I just want to say he appeared willing to converse with me.
Did he mention his legal counsel?
He mentioned hiring Deborah Salisbury, and that would have been part of the family court process, which is a separate process from my criminal investigation.
In your experiences, do leaders of, quote, police parallel services, end quote, paramedics/firefighters usually have more or less knowledge of their civic rights than average citizens?
I would not have an answer to that.
Did Jack demonstrate any non-verbal behaviors that made you feel the discussion was not wanted?
No.
Were you there to, quote, get to an anticipated conclusion, end quote, or, quote, to seek the truth, end quote?
Can I expound on that?
What a question. What a question. The jury is performing cross-examination. The jury is crossing these witnesses. This is cross. This is cross-examination.
My answer.
I think you should answer the question that was actually asked.
Could you repeat the question?
Were you there to, quote, get to an anticipated conclusion, end quote,
God.
or, quote, to seek the truth, end quote?
I was conducting an investigation to get to the truth and matter of fact.
Did you inform Jack the reason for the interview?
I don't recall the exact verbiage, but I would have expressed there were some concerns. We'd received reports from Department of Children and Family, and I was following up those reports.
There's
You said it was
DCF again.
probably your iPhone that you recorded your interrogation of Jack. Where was your phone during the interrogation?
Like I said during my first test, the initial testimony, because of the clarity, it very well, I mean, it sounded clear. It was on the table. Obviously, I sounded louder in it. Might have been sitting next to me. But I don't have, right at this moment, that was many, many years ago, I don't have a clear recollection. That's would not be unusual for that to happen.
Was Jack given the notice the meeting was being recorded or to refuse the recording of the interrogation?
Well, it wasn't an interrogation, it was an interview. And no, there's no right to.
This jury is thinking in their head, well, you and I must have not listened to the same tapes. It wasn't an interrogation, it was an interview. This jury disagrees with your characterization of that recorded discussion. I'm just saying.
Privacy when you're talking to the police, whether that's in the back of a patrol car, in a hospital, at their house, it would be common for me to record an investigatory interview.
That is a true
Yes,
statement.
no.
That's a true
Does the
statement.
recording of the interrogation have a recorded opening with names, date, location, and consent to record?
It did not.
If not, then is it your usual modus operandi to record interrogations without the knowledge of the interviewee?
God,
It
the
would not be
most
unusual to do
operandi.
that.
And members of the jury, those are the questions I'm going to be able to ask, and I cannot ask the other questions. Defense, is there any follow-up?
Detective Graham, why do you make the recording?
it is the most accurate account of what is being said for both myself and for the person I'm interviewing.
Lindsay,
Any
thank
further
you.
follow-up?
On the passage. Now I gotta put it in that.
Oh God, can we control the white noise machine, please?
You would put, did you tell Jack Kowalski that you don't care, that you would put he and his wife in jail tomorrow if it means Maya gets better?
If you're saying that's what the quote is, then yes.
Oh, way to have that on reserve. And that was a long ass pause.
Jack Kowalski that you don't care, that you would put he and his wife in jail tomorrow if it means Maya gets better?
If you're saying that's what the quote is, then yes.
And did you remind him of what good it would do to Maya or Kyle if both their parents were put in jail?
Objection. Argumentative.
Overruled.
Could you repeat the question, please?
Did you tell them or ask Jack what good it would do if Maya or Kyle, or if both their parents were put in jail?
I'd have to look at the, if you're telling me that was the transcript, but I'd have to see the transcript itself. Yes.
Mr. Anderson, can you show me?
Morgan, here's the thing. The bias questions, this is how the case is. This is the position of the case. This is how the
Very
jury is
end of the
expressed.
conversation. I see what the
The
quote
defense
is.
has work to
Yes.
do.
And so, what did you tell him?
Do you want me to read the blue highlighted area?
You don't have to read it, but let me just ask you again. You were telling Jack Kowalski, you were giving him an opportunity because, and you asked him again, what good does it do if Maya or Kyle have both their parents put in jail?
That was what was said in the transcript. I forget what was the question. If you could go back.
You answered.
I did. Okay.
Anything further?
Yes, briefly, Your Honor. He showed you, Mr. Anderson showed you a page from what looks to be page 168 of the transcript.
Yes.
That conversation that he's referring to came after all of the statements that you and Jack had that we published to this jury, correct?
Yes, I recall this was at the very end, and that I was expressing to him.
Shapiro. So, for those of you trying to keep track of where this jury came from, I made comments at the beginning of trial that I didn't like. I don't like cross-exam questions where it's, are you telling this jury, right? When someone says, are you telling this jury, right? There's an element lost there. It's, you're creating, I don't know how to express it. The sarcasm is present. You are creating a body politic. You are giving them a gravitas. You are giving them a title, right? And by doing that, you have said, are you telling this jury, are you telling this jury right here, are you telling them, respectfully, counselor, are you telling them that they should disregard the truth in favor of your lies, right? It's this jury comment. That was Shapiro beginning with a lot of cross. And I was critical. I hated it. I can't stand that. I hate that question. But then this particular jury started to own that. And they became this jury. They started referring to themselves as this jury. So a lot of what's occurring right now was actually reinforced by Mr. Shapiro himself. Mr. Shapiro himself, by implying in all of his cross-examination questions to the various witnesses called on behalf of the plaintiff, to all of those witnesses, Mr. Shapiro did say, are you, Mr. or Ms. Witness, telling this jury A, B, C, D, E. To which the witness responds, why, yes, I am, or no, I am not. So this jury has been embodied since the very beginning of this trial. And the defense can look at nowhere else than their own questioning and cross-examination for the re-emboldening and the formation of, quote, all capital, this, end quote, jury. That's what you have. That's what you have.
Because he had expressed to me during this conversation that he was protective, he was encouraging, he was being the protective parent. And I was just expressing it doesn't do any good for both parents to be in jail. It doesn't do any good.
Well, let's explore that really briefly since you brought it up. Were those comments made as encouragement to Mr. Kowalski to be protective of Maya?
Yes, because that is what he had conveyed to me during the course of our entire interview.
And
He would do anything, and even said he would go to jail tomorrow if he was responsible.
right, and the comment you made was not about your desire to separate them. It was Mr. Kowalski telling you he's protective and that he wanted to have Maya home.
Yes, that was his ultimate goal. Was
At no time in your interview did you ever threaten to arrest him, did you?
no,
Okay, ever. You can answer.
no. In fact, at some point during the conversation, I think I said you're not under arrest.
And you
Okay, we need to fast forward. So we need to get to arguments. Here is the part that we were arguing about towards the end of the day. And this became a very, very big part of the argument. We're going to go all the way to the end of the stream because the judge gets into a back and forth with a lot of the parties here. I'm going to start pulling up super chats. I have to. I really have to. Recovery Addict, I cannot do the rest of the show in this accent. I can physically do it, but I do believe that the chat might have opinions when I get down to the actual discussion of the law. It takes me a while to do the Southern Virginian because this is, in fact, while people think it is foghorn leghorn, it is not. It is actually Southern Virginian. That is the accent that exists. And I know this because I had opposing counsel one day from the dear South Virginia area make the comment and leave a voicemail. This is Mr. Cloete leaving a voicemail for Mr. Morrison. If he could please dial me back on the following number, it would be most appreciated. And I said to myself that accent right there is the embodiment of the Commonwealth of Virginia, and that shall be a personality characteristic that I shall embrace and use effectively and in sporadic moments of, well, provocation. When I'm provoked to that extent, I will use the accent, but not for the rest of the show because I have to talk quicker than this accent allows. So we get to the end.
What's next?
Judge, I think that's all we can address.
we're going to go back through these, and if there's any more, we'll let you know. But I think that's going to be almost everything.
Come on.
The redactions under that last paragraph says begins currently. You can see two redactions, which would be insurance companies. And so, yeah.
What about here?
It doesn't seem to be an actual issue.
Here we go.
Only
This one.
any care treatment.
So here's the thing. Here's the premise leading up to it. The premise leading up to it is, and I'll tell you what the other witnesses we had, they were doctors, the doctors that were existing. Side note, love the pause game. Going to call this out real quick. Ms. Lawrence, sitting first chair. Ms. Lawrence sitting first chair. Young lady, congratulations on sitting first chair. First chair, lead counsel for the plaintiff. God bless. I still want to hear you introduce everybody. When they call court on Monday, please, God, plaintiffs, let Ms. Lawrence do the introductions. Please let her do it. That would make my day. I think I would cry in happiness. Anyways, so here's where we are right now. Where we are right now is they have been discussing various things that were blog posts on Maya Kowalski was writing, and they were very uncomfortable to read. They were Maya Kowalski writing as Maya Kowalski during the time that she was in the ketamine-induced coma. They were uncomfortable. They were very uncomfortable. They sounded very much like, honestly, if you're looking at Munchausen by proxy, they sounded like that. They read like that. It made sense in that moment. I was reading those and going, well, shit, if the hospital had this, that makes sense as to how they got there. And then I thought about a lot of the things that I heard earlier in the day. Earlier in the day, we heard testimony from various physicians. The doctors were testifying to diagnostic methodology and CRPS treatment. And there was a lot of this that was focused on how Maya presented and whether she presented at prior interactions with medical providers as someone who had CRPS. And during the course of all of this testimony, I was going, this is good for the hospital. This is great for the hospital. Because the doctor testified to the various modalities you use to treat CRPS. It was occupational therapy, which is moving about, doing the things, physical therapy again. And then it was cognitive behavioral therapy, right? So that was the doctor who testified that this is how I treat it. And now the doctor was clear when being cross-examined that there are other doctors and physicians that treat pediatric CRPS with the use of different pain medications. So this particular doctor, what he was doing was creating avenue for Johns Hopkins, all Children's Hospital, JHATCH, to basically say what we did as far as treatment is not out of line. We did cognitive behavioral therapy, albeit 3 hours, physical therapy and occupational therapy. We did that. We did what this doctor said they do in their course of treatment. But a lot of this was going back to the question of whether Maya had CRPS. And I was going, does it matter? Does it matter? Does any of this matter? The primary elements of the plaintiff's case right now, to me, appears to be the things that the jury is focusing on most. The conduct of the hospital, despite any diagnosis of CRPS. It's the conduct the hospital engaged in. I mean, I focus on 3 particular incidents, right? You have the 48 hours in that room that the hospital says was for whatever reason, but you have the hospital tries to claim it's for medical purposes, like it was for medical treatment. But then you have the risk assessment file, which tells them to put her in this room for observation. Those do not coincide, right? Then you have the hospital acting outside the scope of the DCF orders in denying privileges, denying things that the DCF orders said should be allowed, but the hospital denied, exceeding the scope of authority they had. Then you have what I think is probably the strongest claim they have, which is the photographing incident, where Kathy Beatty is alleged to have photographed Maya against her will at the instruction, what she says, risk management, but also questions about whether she did it volitionally of her own choice. Those are the 3 incidents that I point to, that I look at. And when I go back and listen to these other witnesses testify, I'm sitting here going, does it matter? Does the CPS diagnosis matter if I'm looking at those 3 as being the primary causes of action? I listened to a lot of medicine today, and the only thing I'm left with is, okay, now explain to me these 3 incidents. Explain how those 3 incidents were within the normal and usual course of acceptable practice for whatever diagnosis you were treating at that point in time. So we get to the end of the day, and clearly I'm not the only one that's asking this question. I'm not, because this becomes the primary focus of a lot of the inquiry. Guys, I hate that I'm doing this. Don't laugh at me. I am doing F and F. I'm moving it to 11. I'm going to be up that way anyways. I'll be up. If you guys are up and doing it, I'll be there. I'm going to be up that late anyways. I might as well do it, but I'm moving it to 11 because this part I really did want to talk about quite extensively. And yeah, I'm talking Oklahoma. I'm talking that case. It's too cool not to talk about. Everyone's just laughing right now. Everyone's laughing. That's fine. But now we get to the big part of today, which left me with so many questions. I have questions. Do you have questions? I have questions. You know who has questions? The Emily robot has questions. Let's swoop a doop.
Not provide, we were trying to transfer to other institutions that had a higher level of care for this. Yeah, I think that you can see this psychological or watching stuff on the screen. We'll go through them. We have other things we can discuss rather than.
Thank you.
I didn't realize we were probably doing that. Sorry.
Yeah, 3168, Judge.
3168.
This is in March of 2016. The auto writing to the church requesting this information be put in a flyer for a fundraiser. Seeking money for more ketamine booster infusions.
Well, we object, Your Honor. I think the redactions there are prejudicial, and the idea that she's doing this for financial gain is what the defense wants to get at. So there's no way to do this. Well, part of the Munchausen diagnosis or theory is that a parent's doing this for ulterior motive. So they want to argue that Maya Kowalski is putting her daughter through all of this because she can make a few $1,000s. The redactions under that last paragraph says begins currently. You can see two redactions, which would be insurance companies. And so, yeah, it's expensive, but the reason she's seeking money is because insurance doesn't cover the treatments. So I don't know how you can extract that and then make an accusation against the mother that she's doing this all for financial gain.
I just had a clarification. Are the plaintiffs alleging in this case that we misdiagnosed Munchausen or no?
Well, let me ask you this. Is the hospital contending that mom had Munchausen?
Well, the diagnosis code that we have to defend says one of the reasons for transfer. It's in the diagnosis. So it's one of the diagnoses. Are the plaintiffs alleging that that's a misdiagnosis?
Because I've been unclear as to whether the defense agrees that Maya, whether she does or does not have CRPS.
The defense of this case from a medical malpractice standpoint is that whether this was psychological, RSD, conversion disorder, Munchausen's by proxy, the treatment would be the same: physical therapy, cognitive therapy, occupational therapy.
This is new information to me, Mr. Shapiro. This is new information to me.
Therapy. What I'm asking the plaintiff is the plaintiff alleging that the Munchausen diagnosis?
Hang on. Emma Daisy. Thank you. Emma Daisy just gifted 50 memberships. Thank you. That is exceedingly kind.
Diagnosis was wrong, that we committed medical malpractice by having that appear in our record, that we committed medical malpractice by having that on the transfer code, that it goes to that because of that allegation that pushed the audit to some type of intentional infliction of emotional distress. If they are, then we absolutely need not just these that are going to hand to court, but these things of fundraising because it does go to the diagnosis. So the answer to Your Honor's question is we don't plan on making this case about whether she had, which disorder they had, but we definitely, if the plaintiff is going to allege, which I think they have clearly, that the diagnosis of Munchausen inflicted distress, stopped transfers to the Moors, was a medical malpractice diagnosis, then this would go to our defense to say that that diagnosis was one of the working diagnoses on the district.
Yeah, I'm unclear.
Mr. Shapiro, Your Honor is unclear. So is everyone else. What in the hell have we been arguing about this whole trial?
Okay.
Because I go back to opening statement, and Mr. Hunter made a statement to the jury to the effect of, we did not have to be right. We only had to be reasonable. Correct. Which I thought was an interesting statement at the time.
We all did. We all did. That statement kicking it off to the jury after the plaintiff's opening statement, which was awkward and uncomfortable, but kicking it off to the jury by the defense, we don't have to be right. We just have to be reasonable. While technically an accurate reading of the law, sets a very interesting tone for the jury. So, yeah. Now the question is, Shapiro just said the course of treatment would have been the same regardless of what she was diagnosed with. Okay.
But I'm unclear now by what you're saying, whether the hospital agrees that Maya Kowalski has CRPS. Because I mean, I just heard a whole bunch of depositions today that seems to suggest that the hospital is saying she doesn't have CRPS.
The hospital's position on this, and from the defense's point, is very clear. The diagnosis of CRPS is questionable. Whether she has it or not is subject to debate because there's no.
How? Wait. Whoa. How was that clear? The diagnosis of CRPS is questionable. Whether she has it or not is subject to debate. What are we arguing about?
Test to rule it in. There's no test to rule it out. It's a syndrome. It's not, you can take a blood test and say that, you have
Accurate.
CRPS the way you can say you have leukemia. But
That's accurate.
From all children's point of view, whether she had CRPS, whether she had psychosomatic pain, conversion disorder, whatever the new language was that you heard from the doctor, the medical treatment for this is the same. Cognitive behavioral therapy, physical therapy, occupational therapy, all of which we provided, and all.
And then I'm saying that's when Shapiro says this then gets me back to my original point. That gets me to my original point, which is now we're back to where I was earlier. Okay, so you've now laid out the standard of care that's engaged in by the hospital. Get me around circumstances 1, 2, and 3, the ones I laid out. If that's the issue we're talking about, that's the issue we're talking about. Then why bring in the Munchausen by proxy? Why bring in all of this stuff? I'm really confused right now.
All of which, to the extent we could not provide, we were trying to transfer to other institutions that had a higher level of care for this. Yeah, I think that you can see in the discharge that if it's on the admission diagnosis, we provided treatment for her if she would have had it. It's also on the discharge. CRPS is on the discharge diagnosis as it can't rule out. So the hospital's position on this, I don't think should not be unclear to this court or to this jury. We are not taking the position that Maya never had CRPS. It was a diagnosis that we considered, we respected, we provided treatment for, just the same as if she had a psychosomatic disorder. And on the discharge diagnosis, it says it can be ruled out. So
we never took a position on the diagnosis, but we billed for it. I'm sorry. Square that circle for me.
If that answers the court specific question about what our position is on CRPS, there's just not a blood test for this that we can say, yes, she had it or no, she had it.
I heard what you're saying. I'm not sure I think it's a clear answer, but I hear and I appreciate the line you seem to be trying to walk, but I'm not sure I totally understand it being a clear answer.
I'll try to give it to you in 10 seconds. To the pain management team, it didn't matter. The treatment for, and Dr. Elliott has testified to this, our pain management team testified to it. I think the ICU doctors, I thought, testified to it, but our pain management people will testify to this. The treatment for RSD/CRPS is exactly the same treatment as cognitive behavior, as conversion disorder or any psychosomatic, or I think was called central sensitization disease. It's cognitive, physical, occupational therapy. And to the all children's team, it didn't matter whether she had CRPS or not.
Well, then my question back is, does it matter whether mom had Munchausen? Because one, Johns Hopkins All Children's Hospital is taking the position that it's a children's hospital. It's not an adult hospital. It did not seek to provide any care and treatment. There's certainly evidence that's been adduced that this is a diagnosis that would impact the yada. Frankly, I'm struggling to see how it goes to what type of care for CRPS that the hospital did or did not provide to Maya, and the focus is on Maya for medical malpractice. So that, I'm struggling with why we're spending so much time on it when it doesn't seem to be an actual issue in the case.
Only because the plaintiff has injected this into the case, saying that your diagnosis of Munchausen by proxy or as a reason for the transfer is the reason we couldn't accept the transfer, and it was a negligent diagnosis. Your diagnosis of Munchausen by proxy caused intentional.
Correct me if I'm wrong, but I don't think the basis of medical malpractice is the diagnosis that precluded a transfer. Is that, am I misunderstanding the case?
Now we have to divide our brain in half. Now we have to say, brain, divide. So this half of my brain needs to focus on medical malpractice. standard of care, breach of that standard of care. This half of my brain has to focus on intentional infliction of emotional distress. Malpractice. Was there a standard of care based on the diagnosis that was breached? Okay, that's what we're talking about here. IIED, intentional infliction of emotional distress. Did the hospital engage in a course of conduct by accusation, by accusing Munchausen by proxy? Did that course of conduct, the accusation itself to the mother, was that an intentional infliction of emotional distress that caused the suicide? So we have to divide our brain in half here. And that's why this is now becoming exceedingly complicated. So Shapiro's like, I can sum it up in 10 seconds. Sir, no, no, sir, no. You need a book to sum this up. It's not that easy. You can sum up the malpractice claim in that quick, but no. IIED still outstands. The accusation itself is still an allegation the plaintiffs are allowed to make. They're allowed to focus on it. But what the hospital was trying to do was the hospital was focused on this transfer diagnostic, this Munchausen by proxy as being the diagnostic for the transfer, and that's setting the standard for the reasonable care. And that part seems to be kind of falling apart from what I'm viewing here, from what I'm seeing. Because, I mean, that part is one of the things that the defense has been trying to do repeatedly is both prove that Maya does not have CRPS, because that's what you hear every witness saying. Maya does not have CRPS, and prove that the Munchausen by proxy diagnosis was correct. But if the med mal claim on that is out, then they don't get any of those documents. They don't get any of those letters. They don't get any of those things. None of that comes in. Because all the IIED relies on is the claim. That's where we are right now. And the judge trying to hammer this home, trying to figure out what the hell we're talking about.
That specific question, whether the listing of Munchausen by proxy on a transfer diagnosis is not the basis for a malpractice claim, that was first an issue raised in this case by the defense when they attempted to claim that effectively Jack and Beata had been unreasonable for not accepting that psychiatric diagnosis in that transfer, and it was on them for not accepting the transfer to Nemours. Then we get testimony that Nemours doesn't in fact have a CRPS inpatient program, and Ms. Beatty lied on the phone to Beata Kowalski, and it was a psychiatric diagnosis they were trying to transfer her for.
Let me stop you because I need to understand. Is the plaintiff saying that there was negligence on the part of the hospital having to do with having that diagnosis, the conversion / Munchausen, as a medical negligence on failure to transfer?
I just want to rephrase the question to make sure I'm understanding. Is our position that it was a breach of the standard of care to use Munchausen in the transfer diagnosis? Am I understanding?
Yes, Judge Probs.
Are you claiming any sort of damages? Let's do it this way.
Sure.
Any sort of damages associated with a non-transfer that occurred on whatever date that was or that time period?
Whitney doesn't have authority to make this call. He is dodging the question because he doesn't have authority to make this call. This is a lead attorney call with the client. Like this question is so much more significant than what gets handled at this hour of the day. This question right here could potentially eliminate a massive part of claims. Like it narrows the focus of the trial, but it's a big money element that gets cut out. So Whitney is not lead counsel. He does not have the authority to make this call. And the judge starts to recognize that. When the judge starts narrowing in on the question, the judge starts to recognize that they need Anderson. And it's not just Anderson. They need both legal teams to come to a consensus as to what their arguments are. this snippet at the end of today was so significant that it alters the entire landscape of this trial.
When was the Moore's transfer?
There was two attempts, right?
It was in November, and I would only, if I may, Your Honor, I would even broaden that to ask the plaintiff, are they seeking any damages from this defense for the diagnosis of Munchausen by proxy? If they're not, that may simplify what Your Honor's concern is.
Well, I'm going to try to answer the court's question first. I don't believe we're allowed to seek damages from the transfer attempt in the context of a Chapter 39 proceeding. I think that was a defense theory raised to muddy up the false imprisonment claim. And now I'm hearing that this transfer diagnosis or transfer attempt wasn't even made until the middle of the dependency proceeding when Chapter 39 shelter order was in place. So, I'm sorry.
No, go ahead.
With respect to Munchausen by proxy, I think the court a second ago spotted the issue, which is that's a diagnosis of the mom. So they take a position that's duplicitous. That is in their records, Munchausen by proxy, there's no question. But then they retreat and say, well, we're a pediatric hospital.
Whitney can't divide it. This is the on-the-spot thing. This is why I said Anderson needs to be there. It took me all damn afternoon to divide this question in my head, like to divide it in half. Whitney is talking about he doesn't want to lose the IIED claim. He can't. That claim, that foundation, that claim results in, or is founded in the accusation that Beata has that this Munchausen by proxy diagnosis is something they weren't allowed to do. So he can't abandon that claim, but he also is trying to figure out how this affects the medical malpractice claim. Like Whitney, to be caught off guard like this in court with this question, he does a remarkable job in answering and dodging and trying to manage the question. And this isn't a question that you can answer on the spot. You have to take time. You have to consult your client. You really do. Because the answer to this question dictates how the case proceeds massively.
We can't treat and diagnose adults, but yet their records of Maya Kowalski are littered with an adult diagnosis. We have been asking the question for years, and this is what you're hearing. We can't get a frank admission as to whether or not CRPS was or was not a diagnosis of the hospital they were treating. We've tried innumerable times. They won't commit to what their diagnosis was. And then to take the position that the treatments for all of these conditions are identical. No, that's preposterous. But secondly, if that's true, our breach of standard care, Dr. Duncan testified to this. If you're taking the position that all of these conditions, no matter what they are, require cognitive behavioral therapy, and you provide 3 hours of cognitive behavioral therapy over the course of a 3.5-month admission.
There you go. That's the med mal.
You can go with that for the moment.
That's
and
med-mal.
it's a breach of the standard care no matter what diagnosis they ultimately land on, but they won't land on one.
Well, with respect to the first attempt transfer, the one in October that occurred during the period of time for the claim of false imprisonment, it seems to me whether mom had Munchausen or not is not the issue, because the issue is mom didn't want to sign the form because of that diagnosis. So even if the plaintiffs, or even if the defense said, well, mom had Munchausen, that doesn't change the fact that mom wasn't going to sign the form. And so that doesn't go to the question of false imprisonment.
Right. The form
so how does it go to Maya's medical malpractice?
Lynn, excuse me, this is the question we're talking about right now. Thought about the end of the day, they're saying both diagnoses are valid, but they can't coexist. We're now in this world right now.
This claim or any claim that's actually remaining.
Thank you, Happy Annie, for the very generous
correct.
chat.
That transfer attempt was in November.
I'm sorry, I pulled that out of line. Happy Annie, just found out my son needs eye surgery and he could still go blind in one eye because I didn't get his eyes checked sooner. I'm scared. All it takes is one teacher, neighbor to report, and I'm under investigation. Happy Annie, I am sorry that you're going through that. This case is not your case. These facts are not your facts. please get your son treatment. It's really important. But thank you for watching and observing.
But I would just reiterate this.
The first one was October.
The first one was October. The form was for a November transfer.
Okay.
But all that being said, I think I see exactly what the court's question is. So I would ask it again. Are the plaintiffs seeking damages from my client for any of the counts for what they're alleging is a miss or a false diagnosis of Munchausen by proxy? If they're not, if we have a stipulation from the plaintiff, we're not seeking damages from you, the diagnosis of Munchausen by proxy, then I don't have to put on a case about why that diagnosis was correct. So I turn to the plaintiff and ask him that again.
What I want is I want the defense team to huddle inclusive of Mr. Hunter and the plaintiff's team to huddle inclusive of Mr. Anderson. I want you all to talk about this issue. It's both what Mr. Shapiro was just saying, but I also think it goes to the question of whether the hospital is going to contend or not that Maya has CRPS. Because, I mean, I hear what you're trying to say, but
Okay, that's where we're going to wrap the in-court coverage. And I'm going to get caught up with questions and then kick over to FNF. Okay, I told you I'd get there. Gingy Probs, thank God it's Friday. Been a while since I caught a live. Thanks for your coverage. My question: the trial seems myopic. I'm behind on this one, but isn't the whole issue that the docs and social workers, maybe agents of J. Hatch, held her erroneously? It feels muddy. It is muddy. That accusation has been thrown around a lot. And one of the things the judge has said is that if the mud ends up in the face of Johns Hopkins, then Johns Hopkins should have avoided the muddy situation. That's it. And a lot of people are kind of siding with that. Josh G, if the police aren't investigating the doctors who prescribed the treatments, how could they have any case against the Kowalskis? It's a good question. AG, how hard do you think the defense is sweating with the witnesses after witness being wrecked by hostile jury questions? Change your tactic, defense. Talk to your witnesses. Change your tactic. In their position, would you adjust your strategy? I would. I would basically say, stop being combative. The jury's going to ask questions. You need to just, I would not have called the detective. I would not have called the detective. That was a net loss. Kara, strong question. Rob, why are some sidebars not muted and others are? Some the judge is okay with the public hearing. Some he's not okay with public hearing. We all get the transcripts at the very end of the day if there's an appeal filed, but in live time, some of the things they're discussing are too volatile for the judge to kind of say, I'm going to broadcast this out nationwide right now. People in the courtroom, I mean, sidebars are sidebars. It's a point for the lawyers and judge to discuss issues of law, which are contentious and difficult. So I don't blame the judge for muting, but the judge also knows that he has the Zoom feed there. He can mute it and unmute it. And he leaves that feed open. So the people that he has deemed capable of reading or watching the Zoom feed, Recovery Addict, are doing so. So I love that coverage. Tara Rayner, at the beginning of the convo, he requested my card question, and it wasn't recorded. And it was recorded question. She said the beginning wasn't recorded. Interesting. I didn't catch that part. Kara Strong, can't the judge edit out this jury and their cross-like questioning? Love this channel. Oh, thank you. Let me reread that. Can't the judge edit out, quote, this jury, end quote, and their cross-like questioning? Not really. You have to allow the jury to ask the question. You just have to edit out the objectionable parts of the question. Love, all caps, this channel. Floated over from Lawyer You Know. Thank you, Kara Strong, for being here. Sunny, Idaho. Ever slipped into the Southern lawyer accent in court? No, but I have. On one occasion, I have tried a case in Orange County, Virginia. Now, in Orange County, Virginia, they do their things a certain way. And when you do not understand the local rules of the bar, you get reprimanded. You get schooled or educated. And that was the only time that I think that you know, you kind of adopt the accent for where you are. Like I can be kind of chameleon-esque based on the people I'm around. Kind of comes and goes. Linda P, could you explain what crime there is after the onset of Maya's pain and loss of mobility? The Kowalskis sought diagnosis and treatment following the advice of some medical providers while choosing not to follow that of others. That is a $1 million question. Actually, that's a $200 million question. Because what people are attributing to be criminal behavior, others are seeing as exhausting all options. And the question is, at what point do we draw the line between parents making decisions and experts at one hospital versus another telling them what is or is not an appropriate decision? So that's kind of where we are. Chelsea, do you think the defense focusing on IIED on Beata and not the other charges is a strategy that could backfire with the jury? I don't think so. If that's on the table, it leaves the jury open for a lot of damages. Gamer Ducko, how long before Shapiro claims hostile judge? No, he won't. Judge been good. Feral Dragon, I can sum it up. A member of your ethics committee predicted maternal FRM their course of actions, and they did nothing to prevent that outcome. Diagnosis was not important. It's possible. Soliolo. Calypsin Vixen has the discharge docs. She's saying there's no CRPS in the discharge. I connected with Calypsin Vixen, and I've got that contact, and I'm going to take a look at some of those docs. But I don't want to take a look at too many. I want to take a look at what was admitted already and what the objections were over. I might take a look at those. Only fictitious conversion and MBP education. Interesting. I see you now. Oh, very clever. The premise is flawed. Thank you. Might be. Midgem, here is some Red Bull and toothpicks for your eyeballs. We'll get there. Promise. Jolynn Elliott, just for giving the accent tonight. Great way to end the week. Much love to you and this channel. Thank you, Jolynn. Thank you to all of you who were here tuning in. Thank you, thank you, thank you. I'm going to go ahead and do this. I'm going to open the chat. I'm going to open the chat for the Friday Night Frenzy stream. It's still set for 11 p.m. There's a thing called food and medicine that I need to put in my stomach real quick. So I'm going to eat, have a breather, a little 20-minute respite, and then we have a very naughty Oklahoma judge to talk about. Very naughty Oklahoma judge, and we will have all of the shenanigans that we have needed to have for a while, because this case is complex and we need to talk about something that's not that complex. So I'm going to redirect you after the end of this stream to that channel, and well, not to that channel. It's my channel, Rob. It's your channel, Rob. To that video. Thank you guys for being here. There are 5,550 of you. The number of people who have shown interest in this case has been exceptional and more than I would ever have imagined. And I have learned so much in covering this case. Thank you for all being here. Thank you for contributing in the chat respectfully, kindly. It has been amazing having all of you. If you would be so inclined, please hit the like button on your way out. If you have not subscribed and you do like the content and commentary, it is free for you to do. Please just hit the subscribe button. We are on our way to 200,000 subscribers. I don't know what I'm going to do to celebrate when I get there, but I might have to make something cool. And I might have to show you how I make it. I think I should do that. I should show people how I make something cool for the 200K, right? I like that idea. Let's go ahead and roll the outro, which is, well, I guess me making something I think is cool. I'll see you guys in a few minutes, okay? Bye.